Item number 24 is concerned, Lordship. Item number 6 is filed your affidavit in opposition. I need to file affidavit in reply, Lordship. 2 weeks time will be granted.
As paid for by Mr. Adhar, 2 weeks time is granted to file the adjournment affidavit. List again after 2 weeks on a date to be fixed by the registry.
Okay.
Make me also. Also, I make to mention item number 25 also. And for the petitioner also, here the standing counsel NMC name has not been shown. Matter is listed by showing the name of the standing counsel NMC. Right? NMC is the main party.
NMC.
Yes.
What is NMC?
National Medical Council.
Okay.
SN Krishna Travis. Item 25.
List the matter again after 2 weeks
Any date also.
on a date to be fixed by the registry. Showing the name SC NMC in the cost list. Yes.
Lordship.
Yes.
With the consent of the other side, I beg to mention item number 30 of today's daily list, my lord. Here, my lord, the respondent number 1 has filed the affidavit in opposition. Against that, I pray for 3 weeks time for filing our affidavit in reply, my lord.
Item 30.
30, Lordship.
Okay, as paid for by learned counsel for the petitioner. 3 weeks time is granted for filing the adjournment affidavit.
Highly obliged, my lord.
May I please?
Yes.
For item 40, Manu, there is the bench method. This is wrongly listed.
40.
14.
14. Mr. A. Boro,
Yes,
learned counsel for the petitioners, submits that the matter pertains to bench 3. Registry to verify and list accordingly.
May I please, Lordship? I beg to mention item number 9. I take a photo for a day.
Why?
Senior, I pay for only passport for a day.
Here for the petitioner,
Yes, Lordship.
as paid for by the counsel for the petitioner. Matter stands passed over for the petitioner.
Deeply obliged. May I please, Lordship?
Yes.
Lordship, prayer for listing of a fresh matter tomorrow. Similar matters has been listed tomorrow. Lordship will remember. Lordship is hearing the matter regarding the certificates which has been obtained prior to the date of interview. They are fixed tomorrow. So a similar matter has been filed today.
It's a fresh case.
Fresh.
It's a fresh case.
This is also motion fresh matter. Can it be tomorrow, Lordship, along with those matters?
Can we allow?
For supplementary also.
We'll cover your case anyway. Whatever matter, whatever orders passed tomorrow will cover your case. It'll come up in due course.
Monday.
You mentioned it before you take it up before the registry.
Okay.
Okay.
Deeply obliged.
Yes.
I beg to mention item 23, the matter may kindly be passed over again.
Pass over. Why?
Lordship, my senior is out of town for medical reason.
You're for the petitioner,
Chief.
as paid for by the learned counsel for the petitioner. Matter is passed over for the day.
May I please, Lordship? I beg to mention item number 20 of the daily list. 20. May I please, Lordship? I beg to mention item number 20 of the daily list. The matter may be possible for the day.
Okay, same. 20, pass over.
My lord, I beg to mention item number 31, my lord. My senior BD Kuar is out of station, my lord, as per his instruction. May be taken on 7th or 8th as your lordship convenient, my lord. 7th August or 8th August, my lord. Some urgency is there in this case. First week of August, my lord. Any date may be fixed, may I pray, my lord?
As paid for on behalf of Mr. B.D. Kaur, learned senior counsel for the petitioner. Matter stands adjourned to be listed again in the first week of August on a date to be fixed by the registry.
Lordship, with regard to item number 2 and 3, Lordship. Matter may be adjourned for the day, Lordship.
2 and 3.
2 and 3.
You're for the petitioner.
Yes, sir.
Why do you want adjournment?
Lordship, we have some instruction from the client that government is waiting to give them the first, Lordship. And
So adjournment only for the day.
yes, Lordship. We have, the client, our petitioner is waiting for the government's order, Lordship.
Okay, as paid for by the learned counsel for the petitioner. Matter stands passed over for the day. Then 2 and 3, same order.
May I please,
Yes.
Lordship? File one pleading application with regard to the last item number 45. That may be called for from the filing section.
When did you file it? When did you file?
Today, it's in the process of being filed, Lordship.
Today only you
Today
file?
morning.
You have the serial number?
Serial number not yet given.
You don't have, then it will not be listed like that.
Only it has to be called for from the filing section. We are completing the processing of filing the matter today, Lordship.
You're going to file and you're mentioning it. People who have already filed are mentioning and we're not allowing, how can that be? Let us see when the matter comes up.
May I, Lordship, I am paying for listing this matter for motion, Lordship, from idle.
Go to the registry.
Lordship, what if the matter was listed before vacation, but due to some problem, Lordship, I have taken time, but.
There's a registrar maintained there, they'll list it. Okay, please go there. Yes, next.
I am also paying for listing one.
You will also go there. Yes.
May it please your Lordship. Lordship, I beg to mention for listing of a contempt case. Lordship, this matter was last listed on 20 March. And in that order, it was mentioned that the case may be come up after 2 weeks. Lordship, still it is not.
You mentioned it, you take it up before the registry.
Lordship, to registry, we have informed it, but again, they have said to mention it.
No, there's a register there, you write, you enter it on the register, they'll take it up.
Lordship, obliged, Lordship.
Yes.
I beg to mention item number 16 for withdrawal, Lordship.
Item number
16, 16 for withdrawal, with a liberty to file fresh.
16,
Yes, Lordship.
as paid for by the learned counsel for the petitioner, Mr.
D. Burua.
D. Barua. Matter stands disposed of as withdrawn with liberty to file a fresh, if so advice. Okay.
May it please your Lordship.
Yes,
As per instruction of the petition of the matter may be withdrawn.
your good name?
A.K. Hangan Bhai.
On the prayer of Mr. A.K. Hanan, learned counsel for the petitioner. On instructions from other writ petitions stands disposed of as withdrawn. Yes, any instructions?
Your Lordship, on the last occasion, Your Lordship, that letter has Your Lordship conveyed to Your Lordship to Deputy Director, Your Lordship. That instruction is awaited, Your Lordship. The fresh instruction, Your Lordship.
So regarding,
ESC has forwarded that letter to Your Lordship, to Commissioner and Secretary to the Government of Assam, Your
so
Lordship.
regarding the appeal being considered and disposed of, no instructions.
Yes, Your Lordship, that is the instruction that is awaited, Your Lordship.
Since 12/8/2024.
Last was Your Lordship.
Almost 1 year now.
2024, Your Lordship.
Huh?
Already we have communicated. Short date may be given, Your Lordship. We already informed it, Your Lordship. And Your Lordship, BSc also, Your Lordship forwarded the letter to the.
None
Commissioner.
appears for the petitioner when the matter is called. Ms. P. Das, Learned Standing Counsel, Secondary Education Department, is present and submits that she may be given 2 weeks' time to come up with the instructions
I'm deeply obliged.
in terms of the order dated 22/11/2024.
I'm deeply obliged.
List again after 2 weeks on a date to be fixed by the registry.
Last occasion also they have not appeared.
None appears for the petitioner when the matter is called. Same was the case when the matter was listed on 24/6/2025. Mr. P.K. Bora, Learned Standing Counsel, Elementary Education, is present. Matter stands dismissed for the following.
Obliged.
Instructions? BTC. This is regarding area salaries. So Mr. B. Chaudhary was supposed to get instructions whether, what is the reason behind non-releasing of the area salaries?
Lordship, I prayed for some more time. Lordship.
Some more time. How much time?
Lordship, 2 weeks.
2 weeks time. Mr. B. The parties are represented by the respective councils. So Mr. B. Chaudhary, Learned Standing Council BTC, submits that he has not received the instruction as yet and prays for another 2 weeks time. Prayers allowed. This is the matter again after 2 weeks on a date to be fixed by the registry.
Okay.
This is contempt.
Yes, first time.
Yes, Lordship. Page 10 is the operative part, Lordship. Para 7.
Read.
Accordingly, this petition is disposed of directing the district elementary education officer Morigao to take steps for which to reinstate the petitioner in his original post in terms of the order dated 14/2/2025 issued by the Director of Elementary Education Assam. Let such steps be taken and completed within a period of 1 week from the date of receipt of a certified true copy of this court order. Lordship, order was passed on 26/5/2025. On 27, we have submitted the application before the PE, but we have not acknowledged this receipt. Thereafter, we have sent for a register post, Lordship. On 16/6, Lordship.
Direction is given to whom? Director.
District Elementary Education Officer, Morrigan, Lordship.
Okay, District Elementary Education Officer. You have soft copy?
Yes, Lordship.
When?
Page 13, Lordship. It is there.
16/6. Will issue notice?
Lordship.
Part Mr.
PJ Dutta.
PJ Datta, Learned Counsel for the petitioner who submits that the order dated 26/5/2025 passed by this court in WPC number 2126 of 2025 has not been complied with, despite a copy of the same having been furnished to him. Stop. Next para, issue notice to the respondent returnable by 4 weeks. Petitioner to take steps for service of notice upon the sole respondent by registered post with AAU within 3 days. List again after 4 weeks.
Okay.
That is your lordship.
We have filed their affidavit yesterday.
Yesterday, I have filed affidavit on record, SLSC meeting, minutes of the SLSC meeting dated 14/7/2025.
Affidavit is not on record. Ms. R. Dekar, Learned Standing Council, Social Justice and Empowerment Department, submits that she has filed the affidavit in the position on 29 July 2025. To stop. However, the said affidavit is not available on record. Office to verify and connect the same to the record and list the matter again.
Monday was. There's some urgency in the matter.
How many cases are there in Monday? So many cases. Monday, okay. Interim order may be continued on Monday. Give the date. In the meantime, till the next date, interim order shall continue. Please.
I think.
May I please motion? My lord, this is a very long standing case. In the year 1997, my lord, I was selected for the post, one post. Kindly see page 20, the honorable court's order.
This is second round.
Yes, second round, because the reason is this, kindly see page 20, operative person page 21.
But where is the case number?
Case number page 20, my lord.
How do you file such kind of next year without the headless? Title WPC number so and so. or civil rule, whatever. Annexure 3, what is that?
Well, case number we have, but actually, it was given like this. The case number is WPC number 1889/1996. However, there is an order that authority will appoint me. In the meanwhile, when some development took place, my father was killed by the terrorist. So on that ground also, the Honorable Court said that entitled to be considered under Assam Public Services, appointment of family members of persons killed by extremists. So in both the regions, I was asked to consider my appointment letter. In that view, my lord, Honorable, keeping in view the order of the Honorable High Court, I filed a representation. That representation kindly see page 22. Page 22. Thereafter, my lord, a number of communications were there, and the government directed the director to take appropriate step for appointment. Kindly see page 24 and 25. This is a letter from the Director Elementary Education regarding my appointment, referring High Court's order. Then, my lord, another letter was issued, that is page 25. Ultimately, 25, this is also from the government. This is Burma IS Secretary of the Government of Assam Education Department. From Contempt of Court case number Rana Chaudhary versus Sri Dinesh Chandra Burma Secretary. So in this letter, my lord, the authority asked the DO to appoint me. And DO said that there is no post. However, in the long run, my lord, I was appointed page 36. Kindly see my appointment letter, page 36. In a grade 4 post, I was appointed. But unfortunately, my lawyer, Mr. K.P. Pathak, the late K.P. Pathak, died. So he did not communicate me about these matters. He could not. So in such
Who expired?
K.P. Pathak, Lord Senior Counsel, who conducted my case in High Court. And at that time I was appointed, but he did not, he could not.
What are you saying? What are you saying? Who died?
K.P. Pathak.
What are you saying? I saw him today in the court during the oath ceremony.
K.P. Pathak. It is told by my junior.
No. Don't make
Sorry,
such kind of
sorry, madam.
statement. Don't make such kind of statement
Srivajyoti Pathak.
without.
No, I'm sorry, madam. Srivajyoti Pathak. Actually, I was told by my junior, he died. So I could not get the appointment, madam. I could not know about my appointment letter. Then I filed various petitions. Lastly came to Guwahati and filed this petition that I should be allowed afresh. Now there is delay, madam. No doubt there is delay, but I have a decision of the Honorable High Court, division bench order, that even 17 years, the report allowed relief when the relief was entitled for. There is also the decision of our High Court that delay alone cannot be a ground to deny the relief. So, well, a notice may go and authority may be directed to produce the relevant papers. Well, I can actually.
Just a minute. See, this page 36. This is an appointment order. Appointment to grade 4 post.
It was passed in the year.
Thereafter, what happened? Then what happened? You're still working,
No, my lord, that was not communicated with me.
or you did not join?
I could not join because this Dhrupajyoti Pathak was my lawyer here, and he was leading, and Mr. K.P. Pathak was the senior counsel. So this Dhrupajyoti Pathak could not did not communicate me, and as a result, I loitered here and there. Last year I came to Guwahati and collected some papers and filing this petition, including they represented to the director.
There's a lot of delay.
Abnormal delay is there. But for the delay, your lordship, I will say this to your lordship, this is the order of the Honorable High Court. Can we see the matter of 2006 relief, relief was of 2006. It is provided in there 2023. Writ petition was dismissed. Review petition was also dismissed. Then I approved the Honorable writ appeal, and there was some observation. And then, my lord, ultimately on 25/9/23, relief was provided to me in the year on 25/19/93, and relief was that was you may kindly see page 5/6. 5/6, both bottom may be seen. Bottom may be seen that the review petitioner or for notional promotion having been carried out by the department by order dated 27/9/22 by no jurisdiction of so and so. And although this court cannot direct the department to pay the arrear salary for the period under consideration for which the petitioner never worked, however, any benefit that would accrue to her as pensionary benefits if the review petitioner is entitled to under provisions of law, the same shall be granted to the review petitioner by the respondent department as such only by way of a clarificatory order. We direct the concerned department to pass appropriate orders as directed above within a period of 30 days. So, my lord, the
Just a
relief-
minute, just a minute. Sir Mahmood, how does this case help you?
No, only regarding
The facts are different, the facts are different.
No, facts are different, but
The facts are different,
read
and the delay part, in fact, it was a continuous process. First writ petition was filed, some benefit was granted, later on, another one was filed. So all this process was happening. In your case, the writ petition was filed in the year 1996. 96. Order passed in 97. Then benefit of the order was given in 99. You're coming in 2025 now. How do we reopen the account?
Open this one, my news file, what I was not informed about the appointment order.
That's too late, isn't it?
Too late.
See,
But
too
I
late,
was
see.
pursuing the authority by filing representations.
You may be
Even-
right, you may be right that you were not informed, but it was your duty also. What is the outcome? Please tell me.
That I understand that.
That you do not do,
We have to one thing only, my lord, limited
So-
prayer.
so we
I
are
have
closing the
filed
matter.
A representation, let it be considered by the government.
No.
Because the appointment letter was.
You have two options, either to withdraw it or I dismiss it.
Appointment letter was issued to me.
Maybe. It's too late in the day. Heard Mr. Mahmood, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks a direction to the respondent authorities concerned to issue a fresh appointment letter to him for the post of peon, bracket grade 4, in the office of BEEO, Gola Ganj, Dhubri. In view of the fact that the earlier appointment letter issued to him on 15/2/1999 was not known to him. Due to lack of communication by his appointed counsel. Stop. Next para. It may be seen that the petitioner approached this court with the same prayer by filing civil rule number 1889 of 1996. And this court, by order dated 26/11/1997, disposed of the writ petition by directing the respondent authorities to appoint the petitioner within a period of 1 month from the date of receipt of the order. Considering the fact that there was one post lying vacant under the establishment of Deputy Inspector of School Dhubri. Stop. It is pursuant to that said order that the petitioner subsequently was given an appointment order on 13/2/1999. Stop. Although the learned counsel for the petitioner submits that he has not been informed by his appointed counsel about the issuance of the order. It is too late in the day to turn back the clock. For a fresh direction like the one issued on 26/11/1997. Stop. In other words, the writ petition suffers from the vice of delay in laches. Stop. Accordingly, this court is not inclined to entertain this writ petition, and the same is dismissed. Ms.
And Fukan.
N. Fukan, learned standing counsel. Huh?
1 to 5.
What is the department?
Elementary. one.
Elementary Education Department. Appears on behalf of respondent numbers 1 to 5.
1 to 5.
My lord, I am sorry, I was wrongly informed by my superior. Actually, I have no idea.
Supposing he was sitting behind you,
No,
then he will sue you.
I
Be careful, be careful.
I understand that. No, that is why he wrongly informed.
You have taken me by surprise because I've seen that person in the court today during the court taking. He was there, sitting there.
Actually, I am extremely sorry because I was wrongly informed.
All right, next time.
May I plead your lordship? Lordship, the petitioners are the Hindi teachers in upper primary school in the district of Goalpara, your lordship. The petitioners are serving more than 25 years, your lordship. But the service of the petitioner not be provincialized by the respondent authorities, your lordship. Similar matter already notice issued, your lordship, by this honorable court on 28/7/2025, your lordship.
You're seeking provincialization of service
Yes, your
as Hindi teacher.
yes.
How many petitioners are here?
89 petitioners, your lordship.
89 petitioners working in different schools.
Yes, your lordship.
What is the basis of your claim? Tell me, what is the basis of your claim?
Lordship, they have been working without any fixed pay with the sole hope that their service would be provincialized.
They have been working without any fixed pay. What do you mean? They're getting pay scale.
Lordship,
They are getting pay scale or what? You are saying that they have been working without any fixed pay.
with the sole hope that their service would be provincialized under 2017 Act, Your Lordship. But the some teachers posts are provincialized, but depriving the Hindi post, Your Lordship. Therefore,
What kind of school is this? LP school,
ME school, Your Lordship,
ME school.
upper primary school, Your Lordship.
Any particular district or or different district?
Yes, Your Lordship. Similar matter notice already issued. Your Lordship.
Please call the Jamada. Okay, you've shown me an order, but I'm asking you, what is the basis of your claim? What right do you have to claim provincialization?
Under section 3(1) subclause 11, Your Lordship.
What does it provide?
Kindly come to page number 32, Your Lordship.
Yes. What does it say?
Paragraph 7, Your Lordship. The petitioner beg to state that pursuant thereto, the state legislature has enacted the Assam Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017 to provincialize the service of the teachers of the Bansar Educational Institution and to reorganize the streamline the education institution up to the degree level in the state of Assam, so as to conform to the prevailing statutory norms and standards. As per section 3(1)(11) of the Act, in case of Bansar Upper Primary School, there shall be minimum 3 teachers or tutors. At least 1 teacher is for science and mathematics, Your Lordship. Second, social studies, and third, language, yes, Your Lordship. Not language, Your Lordship. Under this section, earlier, this honorable court already considered our petition, Your Lordship. That is page number 172, Your Lordship.
What, this is a second round?
No, Your Lordship. Similar matter already considered by this honorable court, Your Lordship, with the direction to the respondent authority to reconsider the matter, Your Lordship. Page number 172. Should, later on. Page number 191, Your Lordship, para 21. In view of discussion and observation made herein above, the present writ petitioners are disposed of with a direction to the respondent authorities to reconsider the case of the petitioners in terms of the provision of section 3111 of Assam Education Provincialization Act 2017. Your Lordship. The petitioners are directed to next para 22. The petitioners are directed to file their individual representation before the appropriate authority with a period of 20 days from today. On receipt of the representation, that may be filed by the petitioners as directed herein above. The respondent authority shall consider the case of the petitioners individually within a period of 4 months thereafter. Your Lordship. I am praying for similar order, Your Lordship, which is first.
Similar order you'll get if you satisfy me, but you have not been able to do that except for showing me similar order, similar order. What do you mean by similar order?
At this stage.
Who are you? And what right do you have to be considered? What does section 3111 say? Are you qualified?
Yes, Your Lordship.
So you
I
say
have
that,
to cite qualified.
say that. You tell me since when you have been working and what is the provision
I
of
have
that?
annexed all the appointment letters, Your Lordship. That is annexure 1 from page number 41, Your Lordship.
Yes, Ms. Sutia, will issue notice?
No, madam, because madam, in this case, madam, 89 petitioners are there, madam.
Ah.
They are from different district, madam.
I see.
And madam, if you also paid their appointment letter, madam, they were appointed by the SMC, madam,
Appointed by the,
the school managing committee, madam,
okay,
without any selection process, madam,
without,
any selection process, madam.
okay. So you will take that stand. What do you want me to do at this stage?
We direct them to file separate petition, madam, from separate district, madam. Because they here, madam, 89 petitioners, some are from, madam, Gwalpara,
Yes, I've seen that.
madam,
They are from different
different
districts.
district, madam. Well, they should come from one district, that will help us to bring instruction also, madam. This is,
But it's possible also that all the districts can, people can file from different districts. The only issue is that there should be a common cause of action, common grievance. All of them want provincialization of service.
Yes, sir.
They may belong from different districts. Where's the harm?
madam, makes no difference.
You have prepared a chart here also.
Yes, Your Lordship.
Well, because districts, scrutiny committees are different, madam.
That is there. No doubt about it.
Mention is number 22, on the table, Your Lordship. District school name, appointment, length of service.
How many districts are involved?
So, 4 or 5 districts.
Hmm? Golpara is there. Golpara is a district.
Madam,
Sonitpur is a district.
madam,
Gwalpara, Sonitpur,
Then
Dhemaji,
Dhemaji is also there. Then Kamrup is also there.
Dorong, and Karbi Anglong.
Dorong. But see your course title. You have only made District Elementary Education Officer of Golpara, Block Elementary Education Golpara. That's all. This is the problem, you see. How they will get instructions? They'll get instructions from Golpara, but what about the others? What do you want to do? We cannot issue notice like that. All these districts have to be there.
Maybe
All the
taken up-
districts officers have to be arrayed as a party. Then only they'll get instructions.
Lordship,
Golpara cannot get instructions for Sonitpur district or Kamrup.
Should the matter may be taken like after some time, Your Lordship.
After some time, what will happen? Court will change his mind.
No, Your Lordship.
Then please write down, by filing this writ petition, the petitioners seek for a direction of provincialization of their service as Hindi teachers in terms of section 3(1) Roman 11 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions close, Act, 2017. To stop, it is however seen that the petitioners belong to different districts. And under the jurisdiction of their respective district elementary education officer or block elementary education officer. Most of the petitioners have only arrayed the officials of Golpara district. Stop, the learned counsel for the petitioners submits that he may be allowed to amend the cause title by filing appropriate application. In view of above, matter stands adjourned. To be listed again after 2 weeks. On a date to be fixed by the registrar. You file one application
Yes, sir.
arraying all the district heads, then we'll see.
I had already mentioned in a table, Your Lordship.
You have not understood what I'm saying. Table is table, no doubt, but the party has to be there of that district. Who is the officer, BEO and all that.
If they amend the concept law.
He has to amend the cost title, that's all.
Okay. Obvious.
Yes.
This matter relates to provincialization of service as tutor in social science subject matter. The petitioner was appointed by the managing committee when the school was at answer stage. Page 21 is my appointment order. I was appointed on 23 to 1994. And page 23, I joined in the school on 24 February 1994. My name has been reflected in the dice board.
Assistant teacher in what subject?
Earlier, there was no such subject, my lord. In the year 1994, only assistant teacher.
I see.
Assistant teacher in a particular school.
Okay.
After 2017 Act has been came into force, there is subject-wise division. Then my name has been reflected in the dice board from 2009-10 onwards. And being found eligible as per the 2017 Act, page 32, my name was forwarded by the district level committee, scrutiny committee, constituted under the Act, my lord, 2017 Act. Page 33, serial number 6. My name is details of tutor eligible for provincialization. My name is reflected at serial number 2, Nirendra Das, assistant teacher, because as per the 2017 Act, 3 teacher service will be provincialized, language, social science, and science and mathematics. Then my name has been reflected at serial number 2, Nirendra Das, against the subject of social science. And clause 7, details of teachers who are not eligible for provincialization due to non-availability of required teachers enrollment. There is my first name, Gaurav Adhikari. He himself projected as he was the headmaster of the school, but as per the 2017 Act, there is no provision for provincialization of service as a head teacher, headmaster, provided if the students exceed more than 100, then additional posts will be created. Then, my lord, when the process was going on, then, my lord, page 35, the headmaster of the school attained the age of superannuation on 31/1/2019. Then the school authority adopted a resolution. We allow the senior most teacher to act as the headmaster, teacher's headmaster. Then, my lord, page 38, this is the statement prepared by the IC headmaster regarding the existing teacher. Page 38, my name has been reflected at serial number 2, showing the date of appointment, date of joining, qualification, and professional qualification. Yes.
What is this?
Professional qualification, this is the statement after the retirement of the earlier headmaster.
Statement prepared by the headmaster.
Yes. Then, my lord, your lordship will appreciate page 40. Statement of sense of impact proposal for provincialization, page 40 and 41. The IC headmaster submitted the statement before the authorities, which was signed by the block elementary education officer, support Salgosa, that the earlier headmaster has already retired from service on 31/1/2019. And when the process was going on, page 43, the director has issued the notification in the website, and the district-wise list was published for provincialization who are eligible for provincialization. In respect of my school, at serial number 530, 531, and 532, page 45, type copy is 44. In my place, this notification was issued on 4/2/2021. And in the approved list, the name of the headmaster has been reflected against me, who has already retired from service in the year 2009.
Where is that? Page 45.
Yes, ma'am. 45, see the
Serial number?
serial number, my lord. Serial number 530, 531, and 532. And name of the retired headmaster has been reflected at serial number 532. Naranaran School, BU support Sargosa.
Har Narayan.
Yes, madam. Before publication of this notification, the concerned authorities have already informed the higher authority that the headmaster had already retired from service.
No, what is this list otherwise?
Otherwise, thereafter, my lord, there have been provincialization, my lord.
No, what is this list?
Well, this is the approved list published in the website who are eligible,
Issued by whom?
issued by the director, my lord. This is the notification. Notification is placed at 43. It's published in the website. And what page 46? The director has sent a letter to all the district elementary officer for drawing of first salary, but there is an indication that those who have already retired from service, their bills shall not be prepared. Page 46. In the second list, the name of the headmaster had to disappear. Page 50. As serial number 514 and 515, because the headmaster has already retired from service and he has occupied my place. In my place, his service was wrongly provincialized, and therefore his name has been dropped out by the subsequent order of page 46. And then, my lord, page 52. The district elementary education officer. My lord, this is the district elementary officer. This is the letter of approval. Then page 53, 8/2021. This is a letter issued by the block elementary education officer to the DU, stating that the petitioner has been left out from the provincialization. The school is situated in a scheduled caste area. The petitioner was the only belonged to scheduled caste, and his service should be provincialized. in place of the headmaster, though his service has been wrongly provincialized before the provincialization order was came to be forced. And therefore, I submit a representation, page 55. And page 54, this is the forwarding letter by the district elementary education officer to the director, forwarding my application for provincialization. And the matter is still pending, my lord. Director has not taken any consideration, my lord. I have visited the office from time to time since I have been working since 1994 till date. Page 56, the certificate issued by the present headmaster. My lord, now I am more than 55 years old. Even today, my service is provincialized. I'll get only 4 or 5 years, my lord. That too, I will receive only 10,000 rupees for the remaining 4 or 5 years. So at this time, my
Please, Lordship, in this matter, my lord, I'm appealing for the department. But first things first, my lord, if Lordship comes to page 43, which is Annexure 6 series. This is the notification he's challenging, my lord.
not challenging.
Where, my lord, he's saying that the wrongfully, my lord, provincialization has been done, my lord, to the headmaster, my lord. So, my lord, the first things first, my lord, he has come very late.
Not-
Now it is 2025 already, and second of all, my lord, rule, if your lordship has the rule, my lord, of 17, my lord, rule 8(6). You should have the act, my lord. Rule at page 118, my lord, of the 17 Act. So, lordship got terms and conditions of service, my lord. Rule 8 is term
100 at page number
118.
118.
118. 118, lordship says, the main thing comes in 17, terms and, rule 8, terms and conditions of service. Rule 8,
just a minute,
subclause 6. Rule
just
8,
a minute.
subclause 6.
Rule or section?
Section, sorry, section 8,
Section
subclause,
8, terms and conditions, yes.
yes. And then, my lord, we will come to subclause 6
Yes.
in the next page. The teachers and tutors provincialized under this act shall hold personal posts to be created for provincialization of their services. These posts shall be outside the cadre, which shall stand abolished on cessation of services by the concerned teachers, tutor, as the same may be due to retirement, death, resignation, or any other reason whatsoever. This applies because in this case, he is saying that the other person has retired from that particular post and he was occupying his occupying that particular post. So upon his retirement, automatically that particular post gets abolished because it's a personal post. So he cannot claim that post, my lord, as per rule 8(6). That post will be automatically filled by a fresh advertisement. So he cannot lay claim.
But tell me one thing,
My lord.
the headmaster had retired already, isn't it?
My lord.
My lord, before
When-
retired,
Rightly or wrongly, my lord, rightly or wrongly, the headmaster had retired. Be that as it may, my lord, at that point of time,
No, after retirement, his name was included.
that, my lord, rightly or wrongly, my lord, rightly or wrongly,
When did he retire?
my lord, 2019.
rightly or wrongly, he should have come that time.
Provincialization order was issued in the year 2021.
Yes, my lord.
Prior to that, the department has already, the concerned authority has already informed that the headmaster has already been determined that my name was recommended for provincialization. So in his place, my should be there.
He
and
should have come that time, my
This
lord. He
submission
should
would
have
be
come at
applicable.
that point of
This
time. my lord.
submission would
He
be
has come
applicable.
now. He has come now, my lord. He should have come at that point of time. He should have shown the irregularity, the arbitrariness. Look, be that as it may, my lord, rightly or wrongly, but this is a statutory rule, my lord, 8(6). He cannot lay claim over that particular post, my lord, because that's a personal post and it is given here in the rule, my lord.
On the therefore,
So
the
that will be
department
filled up,
has,
not by a proper advertisement, my lord, by a fresh advertisement. So that he has no claim, man. We cannot say I should be get that post. It can be some other candidate might get it also.
if
So what I'm on, my lord, is that rightly or wrongly, that person had been provincialized, my lord. So he should have been diligent enough, my lord, to have come to the court and basically got an order, my lord. But he has not. He's come in 2025, my lord, and 19, my
I
lord,
am-
he has retired. He, as per his own records, he's saying 19 he has retired. 21 the provincialization order was given. So it was his duty, my lord, and he should have been diligent enough to have come on that at that point of time. So many years have gone, my lord. So I feel, my lord, there's a question of mental ability arises over here, my lord. Lordship has the
We'll
right
leave-
to exercise, my lord.
We'll leave that open at this stage.
Let me know if you notice only.
That's what.
But Lordship will highlight, my lord, in the order that the question of mental ability shall be remain open.
That will
that will applicable. If if my service was provincialization before my retirement, then his submission will be applicable.
He don't
Because
explain the delay anywhere.
evidently he has already retired from service in the year 19. Department has informed that so and so has already retired. Kindly input his man, consider his case. In spite of that, in the year 2021, his name has been reflected because he has, though he has already retired.
My lord, who's
And
stopping from coming to the court, my lord?
And therefore, on 8/2/2021, page 53,
Why did you come now?
now,
After,
immediately after 2 days or 3 days, the
after 4
department,
years, you're coming. Why?
my lord, because
4 years, you were happy about it.
my lord, I am waiting for the department to,
No, name is already there. How
my lord,
your waiting will not help.
my lord, page 53, department has.
Some other
informed-
name is already there.
Block elementary education has
If the name
already,
was wrongly entered, you should have come, isn't it?
it was come to light when, my lord, after provincialization. Prior to that, it is not known to me, my lord, because 2019 he has retired. Then department informed the authorities that so and so has retired. I was expecting that my name will be included in the provincialization.
So when did you come to know about this?
2021, the department, my lord, page 53,
21.
and therefore, my lord, page in the year 2023, I approached the authority. Page 55,
There is a considerable delay, my lord.
not 11/1 or 2/11. Because they are taking
So
so
many
many
years, my
time,
lord,
up
so
to
many
4 or
years, my
5
lord.
years only to file affidavit.
My lord, question of maintainability, my lord, if to be remain open, my lord. The Rule 8(6) is clear, my lord.
Notice may be issued, my lord, and pendency shall not be barred to consider my representation. Page 55.
Page 50?
Page
Right.
55, representation that was forwarded by the block and district elementary to the director.
My lord, this representation has got no seal and signature, my lord. Whether it was actually given or not, we don't even know.
This is the
Lordship, please-
forwarding letter, my lord.
If your lordship sees
Page
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 55,
54 is the forwarding letter. Application date is there.
my lord, there
The
is
name of
application
objection
date, but there is no,
some difference.
there is no, my lord, listing at all, my lord. There is no, there should be having a seal and signature of the department, nothing.
This is forwarded by the authority, page 54. Application number so and so dated 37/2020.
55, my lord. Is by Nirendra Das.
Reference, yes, reference, district elementary education officer, Chuburi, reference number, application number, so and so. This application has been forwarded.
For follow-up also has not been done properly.
Okay, heard Mr. N. Sharma, is it? You are Mr. N. Sharma?
Yes, ma'am.
Learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities concerned to provincialize his service as teacher of tutor, ME School, Dhubri, with effect from 1/1/2021
Subject of social science.
in the subject of social science, similar to other teachers who had been provincialized on that day. Stop. The learned counsel submits that although the name of the petitioner was forwarded for consideration, but by notification dated 4/2/2021, the headmaster of the school, who had already retired in the year 2019, was included for provincialization. From having come to learn about the same, the petitioner submitted representation before the district elementary education officer. No, to the director of elementary education through the district elementary education officer on 30/7/2023. Stop. However, since the same has not been considered, petition is before this court. Next, para, Mr. A. Cooper, learned standing counsel,
Elementary education.
Elementary Education Department, at this stage submits that provincialization of the teachers is and since the name of the petitioner did not appear in the notification dated 4/2/2021, he cannot have any claim towards provincialization. Full stop. If the name of the headmaster of the school had wrongly been indicated in the notification, the petitioner ought to have come at the earliest, and not after 4 years. Full stop. He therefore submits that the writ petition suffers from the vice of delay in laches, apart from the merit of the case. And apart from merits. Stop. Next, para, in view of above, issue notice of motion returnable by 4 weeks. Mr. F. Pugan, learned standing counsel, Elementary Education, accepts notice on behalf of respondent numbers
1, 2, 3.
1,
5 and 6.
3, 5, and 6. This D.D. Berman, learned additional senior government advocate, accepts notice on behalf of respondent numbers 4, isn't it? Stop. Notice is therefore complete. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing for the respondents today, within 2 days. List again after 4 weeks. The question of maintainability will be considered at the appropriate time.
Well, deeply obliged.
Tendency shall not be a bar, like this, that the presentation. That may be observed.
Pendency of the writ petition shall also not be a bar for the respondents to resolve the issue.
In terms of my representation.
In terms of the representation said to have been submitted by the petitioner.
Right.
May I please?
Yes.
The petitioner is presently serving as the deputy director in the office of the Director of Secondary Education, Assam. He has been posted there on 30/3/2023. And my lord, what happened? He has got his both the parents aged about 90 and 83 years. And they are suffering from old age diseases. And in the meantime, he was transferred earlier by the order dated 27/3/2025, page number 25. Whereby he was transferred from the office of the DSC to Vishwanath. And thereafter, he has submitted one representation on 1/4/2025, page number 27. In that representation, he has stated that he needs, even if he is required to be transferred, he may be accommodated in the nearby places. So that he can take care of his parents. They need his help every moment, And
Where are you now?
at the office of the DSC Assam, the impugn order is thereafter again issued, at page 28, 22/7/2025.
Before 28, what was the order?
Before 28, I was continuing on the strength of order dated 30/3.
No.
Earlier order.
Earlier order is
Earlier
there.
order,
Yes.
27/3/2025.
Where is that? Page.
Page 25.
This is the first transfer order.
Yes, my lord. After
You
that,
are at serial, where are you? Which para?
Page 25, my lord.
Yes, 25, which paragraph?
Last, my lord, last above, second paragraph from the bottom.
What is your name?
Saju Kumar Jadhav.
SK J Yadav, SK Jadhav.
Yes.
Okay.
After that, he has given the representation, my lord, at page 27.
with a request to place him nearby places so that he can come to,
You are in Guwahati,
yes,
the office of the Director of Secondary Education, isn't it?
yes, Lordship.
You have been transferred as DEO Biswanath.
Bishwanath,
Then again by this annexure 7,
yes. From further, my lord, distance place at South Salmara. Instead of giving me, my lord, of accommodation in nearby places, my lord, I've been given in a far difficult.
what happened between these two orders? You submitted some representation.
Yes, Lordship.
Okay.
After that, I have another replacement page number 29 I have submitted, my lord. Annexing my father's other card, my lord, you will also find at page number 30. My father's date of birth is 11/9/1938. And mother's date of birth, my lord, 1/3/1941. And father has undergone pacemaker implant, my lord.
Permanent placement.
Yes. Yes, Lord. Therefore, he has
The
submitted.
court sitting here cannot
Yes, I understand, Lord.
understand about the health of each of the transferees, you see. What is to be done? You can only issue notice at this stage.
And my lord, yes, as per earlier order, my lord, is continuing in the office of the DSC Assam as on date, my lord. So for time being, status quo and today maybe.
What status quo?
Status quo, my lord, is continuing in the existing place, my lord.
The notice may go, your lordship.
The law is clear.
Or
First you go there, join, then you file your case.
or in the alternative, your
It's not
lordship.
that you're sitting in one place, you can say, I will not go there and I have an order. That is the law, Mr. Pupasta, you know
Yes,
very well.
I understand, my lord. So my lord, my
So if you understand, only notice will go.
on my lord,
But
one thing,
Mr.
instead of notice, my lord, may I pray one thing, my lord, that the representation will be disposed of by these respondent number 1, my lord.
How many representations have you filed?
Page number 29, my lord.
Again,
29. That is the latest representation after this order, my lord. That
10 days, 10 days time?
Yes,
Your lordship.
yes,
Within 10 days time.
yes.
Heard Mr. B. Prokashta, learned counsel for the petitioner, and Ms. P. Das, learned standing counsel, Secondary Education Department. Stop having regard to the nature of case projected by the petitioner, comma, the writ petition is disposed of at the motion stage itself. Stop, next paragraph. The petitioner who is working as deputy director in the office of the Director of Secondary Education Assam was given a transfer order by notification dated 27/3/2025, transferring him
To South Salman.
just a minute, with transferring him as the District Elementary Education Officer within bracket DEEO Vishwanath in the interest of public service. Stop, aggrieved with the same, the petitioner submitted his representation on 1/4/2025 before the Secretary to the Government of Assam, Department of School Education. Citing CITID, citing various domestic problems faced by him. So the petitioner also made a request that he may be instead posted either to Baksa, Barpeta or Kokrajhar, so that he can be near his parents, near his aged parents, near his aged and ill health parents. Stop, person there too. The respondent authority concerned, white notification dated 22/7/2025. In supersession of the earlier transfer order posted the petitioner as DEO at South Salmara, within bracket, Mankacha district, with effect from taking over charge. Stop. It is the case of the petitioner that even South Salmara, bracket Mankachar, is situated in a great distance from his hometown. And he will not be in a position to look after his aged parents who are having serious ailments. To stop, the petitioner therefore initiated another representation come to page
Page
29,
29, my lord.
annexure 8.
Yes.
This has been forwarded.
No, it is submitted to respondent number 1 directly.
Oh, this is by you, isn't it?
Yes.
Then you write the statements like this. What does say? Last slide. After that, that one we cancel, okay? The petitioner, therefore, submitted his representation to the senior most secretary to the government of Assam, Department of School Education, on 23/7/2025. Praying for stay of his transfer to South Salmara, bracket Mankacha, on the grounds mentioned in the same letter. Stop, however, since the same has not been considered, the petition is before this court. Next para. Mr. B. Prokasta, learned counsel for the petitioner, submits that the limited prayer of the petitioner at this stage is for a direction to respondent authorities concerned to consider the representation submitted by the petitioner on 23/7/2025 for being posted in any other place which is near to his hometown, in view of the difficulties faced by him in his hometown. Stop. Ms. P. Das, learned standing counsel, Secondary Education Department, has no objection to such prayer. Next para, in view of above, the writ petition is disposed of by with the direction to the respondent authorities concerned, comma, more particularly, which respondent?
Respondent 1.
Respondent number 1, to consider the representation of the petitioner dated 23/7/2025 and to dispose of the same by way of a speaking order within a period of 10 days from the date of receipt of a certified copy of this order. This petitions that stands disposed of.
Till the represents disposed of, my lord, the email cannot be disputed. Date observation.
Your lordship,
Because the ultimate decision.
already
will take-
10 days time has been granted, your lordship. There is very limited time, your lordship, to pass the speaking order, your lordship.
Till then, my lord, we may not be, my lord, at least, till that, acted upon.
Okay. Till the till the representation of the petition is disposed of. No, you just read again the last sentence. Within a period of 10 days from today. Stop. The petitioner shall furnish the representation, a certified copy of this order to the respondent number 1 within 2 days. Full stop. Till the representation is disposed of. The petitioner shall be allowed to remain in the present place of posting.
Like,
Yes.
My lord, this petition is for the enforcement of the provisions of section 12, my lord, of the RTE Act and rule 7 and 8 of the RTE rules of 2011. My lord, it will be probably in order, my lord, if I read out the provisions of the rules before I start in the facts.
How many petitioners are before this court?
My lord, there are 2 petitioners, my lord. One is ages 5 and petitioner number 2 is aged 9, my lord. They are represented by their father. The issue here, my lord, is that they had sought admissions in the respondent number 4 private school under the provisions of section 12, 1C of the Act, my lord, of the RTE Act. Thereafter, my lord, they were charged a capitation fee of ₹500 per child, and thereafter 500 per child. My
For what?
a capitation fee, my lord, for prospectus and the brochure. And thereafter, when the admission was sought to be taken by the father of the petitioners, my lord, in KG and class 3 respectively, an admission fee was charged amounting to ₹17,738, which is expressly barred by the RTE Act, read with the RTE rules. And there is a guideline also, my lord, which has been issued by the Assam government itself, my lord. If I permitted to please.
Why didn't you annex that in your writ petition?
In fact, my lord, this has come to me subsequently, my lord. I had been researching on that.
Tomorrow something, again, you'll find out and you'll hand over like that.
No, my lord, this is the only additional document, my lord. In fact, right now, as of now, my lord, notices may go, but as I'm praying, my lord, that I be provisionally admitted in the school, my lord.
What is this capitation fee?
The capitation fee, as I understand, my lord, the capitation fee is a fixed fee which is charged per individual, per student. Which
For
is
what?
for admission, ma'am. For admission, my lord, the capitation fee.
No,
is
admission fees are there.
Yes, ma'am.
Separately, the capitation fee.
Separately the capitation fee, my lord. This is separately later on in page 32. Annexure E and Annexure F also, my lord. There's a capitation fee for prospectus and the registration form. The expenses incurred in both of these aspects. Page 32.
32 is what? Prospectus?
No, my lord. 32, if your lordship sees, 32 Annexure E.
Yes.
Received a sum of ₹500 only against the fee of prospectus and registration form for the session of 2025-2026. Registration of class KG. Then the subsequent picture, my lord. Received a sum of ₹500 against the fee of prospectus and registration form for the session of 25-26 for class 3. This is for petition number 2. Thereafter, my lord, if your lordship can kindly come to page 33. Page 33. This is a subsequent receipt which was issued to the father of the petitioners, which amounts to a sum of ₹3,739. This again, my lord, is for class KG. The topmost right-hand corner, my lord. Topmost right-hand corner, just below the Happy Child High School name, my lord. KG. And at page 34, there is another sum, my lord, of 3,370.
This is for?
This is for page 33 and page 34, my lord, is for petition number 1.
KG.
KG. Page 35, if your lordship sees the rightmost top corner, my lord, just below Happy Child High School, it's class 3.
It is for the petition number 2. The grand total is rupees 6,954 and rupees 3,720, which is at page 36. Now, charging of any capitation fee, any prospectus fee, any admission fee, my lord, under the provision of section 12(1)(c) of the RTE Act is expressly barred. Thereafter, the rules were also framed in the state of Assam, my lord, in the year 2011. If your lordship may kindly see the applications which have been preferred by the father of the children, my lord, which is at page 28 and at page 30 respectively. Page 28.
Yes.
Yes, my lord. To the principal, so-and-so school, application for free admission of said ward for academic year 2025-2026. I, Mr. So-and-so, on behalf of my ward, Mr. Rehan Barai, who is petition number 1, am writing to express my interest in securing free admission of my ward to your esteemed institution for the academic year 2023 for class nursery. This under section 12(1)(c) of the Right of Children to Free and Compulsory Education Act 2009, read with Rule 7 and 8 of the State Rules of Assam, Right of Children to Free and Compulsory Education. This application, my lord, ends at page 29. The subsequent application for petition number 2 starts at page 30. Same application, my lord, under the same provision.
This is a format.
This is the format. This is the format, my lord. This is not
Everyone's given to, everyone is given the format and they just fill it up.
Yes, my lord. This is what was given to us. This is what we filled up and applied for in the school, my lord, response number 4 school. Thereafter, our grievance lies against the fact that the charging of the capitation fee and the admission fee.
Your application is under 12(1)(c).
Yes, my lord, read with Rule 7 and 8. Read with Rule 7 and 8.
Read with rule?
Rule Assam Right to Free and Compulsory Education 2011 rules, Rule 7 and Rule 8.
Okay.
Rule 7 and Rule 8, my lord.
Okay.
If your lordship permits me to read the rules, my lord.
Yes, what is Rule 7 and 8?
Yes, my lord. Rule 7 and 8, my lord. Rule 7.
Where did you get that? Is it available here?
No, my lord, it's in the Right to Education Act. I have the back. Yes, my lord, it will be here.
No, this is for the RTE, but rule 7 and 8.
Rule 7 and 8, my lord, the rules
Assam
are.
Act 2011.
My lord, the Bayer Act would also have the rules, my lord. It ideally has the rules, my lord.
For Assam.
For Assam, my lord. Every state were mandated to carry out their own rules, my lord, according in pursuance of the Act.
The rules are not same, isn't it? The rule is of 2010. What they refer is the year is
2011, my lord. The rules
2011.
stated course of 2011. If your lordship permits me to read the rules, my lord, it's 2011. The Act was 2009. The rules are 2011. The Act is a central Act, and the rules have been made by each state, my lord, at different times.
So where do you get that rules?
My lord,
There's no book on that.
I have one which is downloaded, my lord, with me. If I may permit to read the rules, my lord. Rule 7 and 8. Yes, my lord. Admission of children belonging to weaker section and disadvantaged group for the purposes of clause C of section 12(1). Subclause 1. Subrule 1. The school referred to in subclauses 3 and 4 of clause N of section 2 shall ensure that children admitted in pursuance of clause C to section 12(1) shall not be segregated from other children in the classrooms, nor shall their classes be held at places and timings different from the classes held for the other children, nor shall an exclusive section be open for them. Subrule 2. The school referred to in subclauses 3 and 4 of clauses N of section 2 shall ensure that children admitted in pursuance of clause C of section 12(1)(c) shall not be discriminated from the rest of the children in any manner pertaining to entitlements and facilities such as text, books, uniforms, library, and ICT facilities, extracurricular, and sports. The areas or limits of neighborhood specified in Rule 4(1) shall apply to admissions made in pursuance of clause C of section 12(1)(c), provided that the school may, for the purpose of filling up of the requisite percentage of seats of children referred to in clause C of section 12(1), extend its limits with the prior approval of the appropriate government or its authorized officer. Now, my lord, Rule 8. Reimbursement of per child expenditure by the government, autonomous council, or the local authority for the purpose of Section 12(2). The total annual recurring expenditure incurred by the government, the autonomous council, or the local authority, whether from its own funds or funds provided by the central government or by any other authority, on elementary education in respect of all schools established, owned, or controlled by it, or by the local authority, divided by the total number of children enrolled in such schools, shall be the per child expenditure incurred by the government. So, my lord, in terms of the section and the class of students which have been referred to in Section 12(1)(c) of the RTE Act, the expenditures which are incurred by such private schools, my lord, are supposed to be refunded by the appropriate government or the state government to such schools.
Where does it say that they shall be admitted free of cost?
My lord, if your lordship may kindly come to of the office memorandum at page 20. The office memorandum at page 20. It's an OM dated 2/9/2021, my lord. And this memorandum, my lord, it pertains to the guideline for implementation of Section 12(1)(c) under Right of Children to Free and Compulsory Education Act 2009 in the state of Assam. Now, my lord, will kindly come to page 22. Page 22, my lord, part B, admission procedures under Section 12(1)(c).
Yes.
Your lordship has fine, please. The first point, my lord, admission against free seats. The unaided non-minority private schools shall display the total number of free seats, my lord, available at entry level, the date of issuance of admission forms, submission of filled-in admissions form for admission against free seats, the date of lottery, the date of display of eligible applicants, the last date of admission on the notice board in the school by the 10th of March every year. No screening procedure, that is interview, written or oral test, etc. shall be conducted for the admission process in violation of Section 13(1) of the RTE Act of 2009, or otherwise the school shall be penalized as per Section 13(2) of the RTE Act of 2009. That's what the Act says, my lord. The State Education Department shall officially announce about issuance of admissions forms under Section 12(1)(c) under RTE Act 2009 to websites, regional news portals, and reliable media. Thereafter, my lord, this matter had come up before this honorable court in a PIL, which was PIL number 30 of 2023. The orders, my lord, have been annexed from page 39 onwards. Annexure I. Page 39 onwards, my lord. This is the first order of the PIL. This was regarding the status of the schools at that point in time, my lord. The order is dated 12/4/2023. PIL, your lordship has found that, my lord. Yes. My lord, the first paragraph in page 41. The petitioners are aggrieved by non-implementation of Section 12(1)(c) of the Right of Children to Free and Compulsory Education Act. It is stated that previously, in pursuance of the orders passed by this court in PIL number so-and-so and PIL number so-and-so, the state government has already issued requisite notifications mandating all the unaided educational institutions to ensure strict compliance of the mandate of Section 12(1)(c) of the Act. Yet many of these institutions who have been included as party respondents in the present petition have refused to admit the children in the current academic session. Then, my lord, your lordship will come to the subsequent order, which is dated 17/5/2023. 17/5/2023. The first paragraph at page 45. These are the facts of that PIL, my lord. The petitioner number 2, present in person, states that till date, out of the 49 children whose names are set out in the list annexure G, only 15 have been provided admissions under the Right of Children to Free and Compulsory Education Act. She alleges that many of the schools are demanding money for admitting the children. My lord, subsequently, page 46. In the meantime, Mr. So-and-so, Learned Standing Council Education Department shall instruct the Secretary, Department of School Education to ensure that 49 children indicated in the list annexure G are provided admission into the schools concerned as per the mandate of the RTE Act, which is without payment of any admission or capitation fee. Because Section 12(1)(c) makes a demarcation for certain disadvantaged and weaker sections of the society. The petitioners here, my lord, belong to the SC class, my lord, with an annual income of around 1,10,000 rupees per annum. We are squarely covered by the previous mandate of this honorable court in the PIL number 30 of 2020.
Okay, so what is your prayer in this writ
My
petition?
prayer right now,
You're seeking a refund,
I'm not seeking refund, I'm seeking admission into my schools, my lord. The sessions have started in the month of April.
but you have made the payment, isn't it?
I have not made the bill.
These receipts which you have shown me,
Receipts are to be paid to them. Refund is one refund of 500 rupees, my lord, which have been made because there are two sets of monies which have been demanded from us. The first set of money was 500 each, my lord, which we have paid. The second set of payment was for the remainder of the amount of 16,000, which we could not afford, my lord. And that is why we moved this honorable court. The 500 per head amounting to rupees 1,000 for the children, my lord, that has been paid by the province. But then subsequently, he was furnished with the money receipts at annexure G and H, which demanded a further payment of around 6,700 odd, my lord. Pursuant to which I've approached this honorable court. It is against the notification which has been issued by the state. It is against the mandate of the act. And it is under, my lord, in violation of the orders rendered by this honorable court in the earlier set of PIL. So as of now, that lordship notice may go, but I'm praying for an interim measure of a provisional admission into the course with remedial classes, my lord. The classes will start from the 1st of August, as I'm told, because there's summer vacation. Because of the ensuing summer vacations.
I'll kindly see page 21 of the notification, my lord. Here, my lord.
21, what? Yes.
Column 15, my lord. Implementation and monitoring committee of different level. There will be two committees for implementing section 12(1)(c) under RT Act 2009. In the state of Assam, the deputy commissioner, principal secretary will be notified the block and district level committee. This committee will be headed by the circle officer, DI, DO, PEO. These are the committees. And my lord, kindly see, there is a grievance redressal committee is also there at page 25. Point 2 of monitoring and grievance redressal. Grievance redressal, the existing grievance and redressal mechanism notified by the additional chief secretary to the Government of Assam, right? Notification number so and so dated 18 September 2014 will be followed. It is in particular, if any irregularities are notified during the process of admission and imparting education, the parents may intimate respective block elementary education officer in writing.
Page 25. Then you had shown me the
Two,
page
part-
21,
page 21, my lord. This is my lord,
serial number 15.
yes, my lord, 15. In implementation and monitoring committee at different level, my lord. Regarding this, my lord, this guideline for implementing the section 12(1)(c) under RTA. my lord.
OM is already there.
My lord. As per the OM, he should have filed an application before the block elementary education in writing. my lord. There is a grievance redressal committee is also there my lord, regarding admission and imparting education.
Yes.
My lord, this matter is not adversarial, my lord. This, we prefer all the alternative route which we have to. But the fact is, my lord, this has been held by the Honorable Supreme Court that if the alternative remedy is not efficacious, if there is not an outer limit which has been prescribed here, this is regarding the academic session of class KG and class 3, my lord. The state government should have no issues implementing the order, their own mandate, my lord. There is this honorable court's direction.
No, what is this school? This is a private school.
This is a private school, man. The
So
private
without,
unaided school, which is covered under definition of 2N of the act.
so the question now is that without issuing notice to them,
Yes, my lord.
it will not be proper to issue such
In fact,
kind
my
of.
lord, they're entitled to read jurisdiction, my lord, as there are various judgments of this honorable court, and plus they're discharging public function. In fact, my lord, time is of the essence in this matter. We'll take drastic steps also, but as of now, my lord, we need to ensure that at least the kids are admitted into school, my lord. They've already lost 4 months. Yes, my lord, 4 months. The primary education, my lord. We follow up any route as your lordship will direct us, but as of now, your lordship will kindly protect us. My lord, these kids come from very weak sections of the society. They haven't had the measure to actually, the financial resources to approach the court. They've taken some time with utmost deliberation and hesitation, they've approached this honorable court. My lord.
Who are the petitioners?
The petitioners, my lord, is the petition number 1 is a child aged 5 years. And number 2 is his brother, my lord, elder brother, aged 9 years. For entry into KG in class 3. Age appropriate classes, my lord. They're represented by their father. In fact, the issue of refund of the capitation fee, your lordship.
Single parent, isn't it?
See, in fact,
Two brothers.
Two brothers. Two brothers, my lord. In fact, the aspect of
This may
refund,
go, my lord.
notice can go, but
This office may go, because my lord, what measures is taken by the private school, you have to know, my lord.
no,
Regarding admission.
the fee receipts are apparent, my lord. The fee receipts are
See, the interim order will consider on the returnable date. Unless we issue the notice straight away, asking them to give provisional, will not be proper.
In fact, my lord, subject to what your lordship finally decides, but the PILs, my lord, which we have just taken your lordship through, the earlier round of litigations, the PIL for the honorable division bench, all of the schools which are arrayed in that matter, my lord, they're private unaided schools. And the mandate of this honorable court, the mandate of the act, and the mandate of the OM, which has been issued by them in 2011, it directly affects and hits, my lord, with the teeth of it, my lord.
And further, my lord, this committee is not a
And
party
your lordship
respondent here, my
And
lord.
your lordship can always revisit the interim order on the next day if subsequent grounds are taken, man. I do not have much to stand on, my lord. The only fact is that they've taken money which ought not to have been taken from me. That is my only ground, which is against the mandate of the act and this honorable court's earlier judgment. And time is also of the essence, my lord, in my humble submission.
Why do you say that?
But
There's a last date for admission.
no, my lord, the admission dates are passed. I'm here seeking entry into the academic session. Before the academic session ends, my lord, I'm in KG and class 3 respectively.
When is the session starting?
The session have already started, my lord.
When?
My lord, in the month of April.
April.
April, my lord, because the first money.
So that's why all the reason that we should not issue such kind of interim at this stage.
No, my lord, we have followed up, my lord. We have followed up with the authorities. We have followed up with the.
Where?
My lord, there are representations, my lord,
Where is that?
at page 37. Page 37, my lord.
37.
Yes, my lord, page 37 and 38. Before the respond number 2.
But they are not the competent authority, my lord, as per the notification, my lord.
My lord, they might not have access to a lot of legal literature, my lord. We follow up as per whatever your lordship says, but as of now, at least the provisional admission that your lordship can always take back.
This is before the director elementary education.
We'll issue notice. That's okay.
My lord, then your lordship will take put a very short notice period, my lord, because once, even if relief is granted after a point in time, my lord, they have already lost out of the majority of the year, my lord.
Heard Mr.
M. Sharma.
M. Sharma, learned counsel for the petitioners, who submits that the petitioners are minors and brothers of the age of 5 and 9 respectively, and they are represented by their father. So the learned counsel submits that the petitioners seek their admission in the respondent number 4 school in class KG,
KG and class 3.
KG and class 3 respectively. But the school authorities have charged them
Yes, my lord.
fees towards prospectus,
My lord,
what else?
my lord, uniform,
Uniform,
then, my lord, books,
books. You had mentioned one thing. What was that?
capitation fee, my lord.
That also.
Capitation fee, my lord, capitation fee we already paid, my lord. That was the first leg of the charging of the fee for prospectors in the brochure.
Okay, then you put etc.
Yes, my lord.
Hmm. which the petitioners are unable to pay. The learned counsel submits that the petitioners belong to a SC category. And in terms of section 12(1) of the Right of Children to Free and Compulsory Education Act, 2009, as well as in terms of Rule 7 and 8 of the State Rules of Assam, Right of Children to Free and Compulsory Education Act, 2011. The petitioners are entitled to free admission in the schools.
And the notification also, madam.
The learned counsel also submits that
Yes.
OM.
OM, madam. Not the OM, my lord, the notification which I've just furnished to put this on.
Submits that
6 June 2011.
a notification has also been issued by the government of Assam in the education elementary department. White memo number PMA stop 627/2010/39 dated 6/6/2011. In terms of section 13 of the Right of Children to Free and Compulsory Education Act, 2009. Prohibiting schools from collecting any capitation fee and from screening the child for admission. Of the learned counsel further submits that the government of Assam in the elementary education department has also issued the guidelines for implementation of section 12.1
12(1)(c).
capital C
Yes.
under the Act of 2009 in the state of Assam, White Office Memorandum dated 2/9/2021, bracket annexure A, close bracket. Stop, however, against the same provisions, the respondent number 4 school has demanded fees. And in view of the status of the petitioners, they are unable to get the admission. Next para, in view of above, issue notice of motion returnable by 3 weeks. Mr. PK Bora, Learned Standing Council, Elementary Education. Department accepts notice on behalf of respondent numbers
1 to 3.
1, 2, and 3. Stop petitioner to take steps for service of notice upon the respondent number 4 by registered post AVD as well as by Dusty. to the registry of this court and thereafter file an affidavit as proof of service. Shall the petitioners shall furnish requisite copies of the writ petition to Mr. P.K. Bora within 2 days. Stop. Next para, also issue notice on the interim payer. Returnable by so and so. We'll fix a date. Give a date. On 21/8. God bless.
Yeah, please, my lord.
Mm.
My lord, in this case, my lord, I'm the second night, my lord. My husband has died for 5 years or I think. President has passed on. Now, my lord, pension will another benefit, my lord. First, I have filed an application before the responsible authorities.
My lord, this is comes under Muslim law. That is why I think he will be entitled, but as per WA, the appeal is there, Mr. BV and his son. But it will come later because private respondents, they have to be go your lordship first. Then notice may go.
Notice may go with the stage.
Notice may go, my lord, because until unless private respondents go, even judgment is there, that is maybe applicable for him, but it will be not, the lordship may not pass the order without private, pleading private respondent.
Your
Notice
name
may
is?
go, my lord.
A. Hussain, madam. A. Hussain.
Heard Mr. A. Hussain, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner, who is the second wife of her late husband, Sharafat Ali, who expired on 26/2/2025, while working as headmaster of Azad LP School, Lakhimpur, prays for a direction to the respondent authorities to release the pensionary benefits to her to the extent of 50% in view of the fact that she is the second wife. Stop. Next para, in view of above, issue notice of motion, tenable by 4 weeks. Who is appearing, Miss D.G. Burman, learned additional senior government advocate, accepts notice on respondent number 3. From Miss S. Supia, learned standing counsel, elementary education. Department accepts notice on behalf of respondent numbers 1, 2, and
6 and 7.
1, 2, 6, and 7.
I'm for my lord.
Mr. C. Barwa, learned standing counsel, AG Assam, accepts notice on behalf of respondent number 4. Not treasury officer.
No, there is a finance.
Oh, on behalf of respondent number 4. Anyone for finance? Is there? Miss R.M. Barwa, learned standing counsel, finance department, accepts notice on behalf of respondent number 5. Stop. Petitioner to take steps for service of notice upon respondent number 8 by registered post with AD due within 2 days, or make it 3 days. The petitioner shall also serve requisite copies of the writ petition to the learned counsels appearing for the respondents today within 2 days. This is the matter again after 4 weeks.
But
Also petitioner before Lord, the assistant teacher
LP school, my lord, is challenged the suspension order, my lord. Please may kindly see annexure 5, page 38, my lord. Page 38. My lord, this suspension order issued on, my lord, 26/3/2025 after arrest, my lord. And already 3 months, well, 90 days is over, but they did not any review, my lord, against this, whether suspension, extension of the suspension is necessary or not. And on the other hand, in last before paragraph, my lord, he is allowed to draw subsistence allowances as admissible under the disciplinary and appeal rule during the suspension period. And copy to serial number 3, District Elementary Education Officer Lakhimpur for information, and you were also requested submit draft charges and statement of allegation. Neither they issued any draft charges, or they allow me to take the subsistence allowance as admissible under the law, my lord. I have not received any subsistence allowance till today, my lord. So, my lord, at this stage, taking notice may go, my lord, and in the meantime, directed to pay the subsistence allowance. As per rules also clearly stated that during the period of suspension, my lord, subsistence allowances must be paid, my lord.
Okay, heard Mr. N. Barua.
Bora, my lord.
I'm sorry, N. Barua, N. Bora. Heard Mr. N. Bora, learned counsel for the petitioner, who submits that the petitioner was placed under suspension by order dated 26/3/2025, bracket annexure 5. On account of were you arrested?
Arrested, man. I
On
was
a-
arrested on 12/2/2025, and bail was granted, my lord.
On account of being arrested in connection with North Lakhimpur PS case number 330 of 2024. However, even after a lapse of 90 days from the date of suspension, neither has the suspension order been reviewed nor the subsistence allowance given to the petitioner. He further submits that the petitioner has also not been given any charge memo with statement of allegations against him. Stop. Next para, in view of above, issue notice of motion returnable by 4 weeks. Miss N. Fukan, learned standing counsel, elementary education.
Yes.
Accepts notice on behalf of respondent numbers,
All the yes.
or on behalf of all the respondents, and therefore no formal notice is required. Stop. Petitioner shall, however, furnish requisite copies of the petition to her within 2 days. List the matter again after 3 weeks. The respondents, no, having regard to the projection made by the petitioner, the respondent authorities shall release the subsistence allowance which is due to the petitioner in accordance with law, if not already released.
Much less. Date may be fixed.
List again after 4 weeks on a date to be fixed by the registry.
Much.
May I please, you know,
Yes.
My lord, matters may be referred to appropriate bench. As
Appropriate when? She's the appropriate when.
Huh?
my lord, certain rules has been challenged in this petition.
Rules. Sorry,
Certain rules has been challenged in this petition.
which rules?
Provide.
Oh, for 14-1, yes, yes, they have challenge rules, so it should go to the division bench.
What is the name of the rules?
Assam Secondary Education Consolation School Service Rule 2018. Pair A, Lordship.
He's right, but the constitutional validity of Rule 14, bracket 1 of the Assam Secondary Education, open bracket, provincialized schools, close bracket, service rules, 2018 is challenged in this separate petition. To stop as per the relevant provisions of the Guwahati High Court rules. The matter has to be laid before the division bench. Stop registry accordingly shall do the needful. I would like to.
I know, boss.
May I please?
Yes,
Lordship, impleadment petition filed paying for impleading the director of pension as contempt number 3, Lordship. Their Lordship matter relates to non-payment of family pension and other retirement benefits, Lordship. The director of pension is a necessary party because, Lordship, the proposal of family pension is to be submitted, is to be proposed by the director of pension, Lordship.
was he a party in the original writ
Yes,
petition?
yes. Respondent number
Okay.
2, he was a respondent.
Any objection?
No.
Heard Mr.
P. Mojumdar, Lordship.
P. Majumdar, learned counsel for the applicant who submits that by filing this application, the applicant seeks impleadment of Shri
Prithvish Kumar Chakki.
Prithvish Kumar Chakki. What is he?
He is the director of pension.
Sure.
Director of pensions. But you have not written anywhere his designation. Okay,
At page number 3, it is there.
Director of pension as a party respondent number 3 in the connected contempt petition. To stop, the learned counsel submits that impleadment is necessary for effective compliance of the court's direction. Stop, Mr. S.M.T. Christie, learned counsel appears for
For the DIF, Lordship, respondent number 1.
respondent number 1 and submits that he has no objection if the application is allowed. Stop.
Thank you, Lordship.
Next para in view of above. Upon hearing the parties and upon perusal of the application from the impleadment application is hereby allowed as prayed for. I stands disposed of. Then in the main contempt, you write, in view of the order passed today in IAC number 2244 of 2025, impleading Sri Prithvish Kumar Chakki, Director of Pensions, not comma, as respondent number 3, the petitioner shall file the amended post title in 2 sets before the registry of this court, whereafter registry shall do the needful. So next para, issue notice to the newly cleared respondent number 3, returnable by 4 weeks. So petitioner to take steps for service of notice upon the newly pleaded respondent number 3 by registered post with any due within 1 week. List again after 4 weeks.
Thank you.
But there is a direction to give the pension to the petitioner. They have said they have had an appeal after 1,000 days delay. till that there is no spare. And this is a case of survival loss. Order of Petition 21, 22. Page 11.
What is the stage of the,
The delay is not yet confirmed.
was it listed anyway?
No, my lord, I tried to find out, my lord, it's not listed. We are trying to list it by next week. Let this matter come up after 3 weeks, my lord. In the meantime, we can price the equipment.
Only thing is that there is this no stay order and petitioner has waited long back, 4 years back. And already looks at the, in similar cases, Supreme Court has passed an order. That person appointed subsequently in compliance with the order. They were selected in 1997, but they have been appointed delay because of their litigation. They have been appointed after a long time. So they are entitled for pension as per judgment of this court, as the Supreme Court is affirming. Now they are filing appeal, and after 1,000 days delay. How petitioner will survive after retirement from service? At least provisional pension looks it. Select list of 1995.
So the question involved is regarding whether you should be covered by the new or the old pension.
Old pension.
Both say that you'll be covered by the old pension. Then
Central government looks at central government has already issued the notification to that effect. Central government, when delay is caused by department itself in giving appointment, in case of advertised post and earlier, before the NPS has been issued, they are governed by the old pensions.
all right. Anyway, see, since appeal has been filed, do you have the number of the appeal?
Well, the serial number is 7710/2025.
170.
7710.
This filing number,
It's the filing number.
delay is not yet listed.
77.
10/2025.
This is the filing number.
Filing.
And delay is 1,102 days.
That also has to be condoned first.
Yes.
Anyway, we'll adjourn it. Time being. Mr. S.K. Goswami, learned counsel for the petitioner, is present. And also Mr. B. Kaushik, learned counsel for the respondent number 2. So Mr. B. Kaushik, learned counsel, submits that
Earlier order also like this looks like. Same order.
appeal filed by the
State.
against the judgment and order of the learned senior judge through filing number 7710 of 2025 is yet to be listed, and therefore prays that the matter be adjourned for 3 weeks. So Mr. S.K. Goswami, learned counsel for the petitioner, submits that there is more than 1,000 days delay in filing the
1,102 days.
said appeal. And in the absence of any stay order, court may consider the instant contempt petition. Stop, however, having regard to the appeal having been filed, this court deems it fit and proper at this stage to grant adjournment for a period of 3 weeks. This is the matter
They
again.
have also not filed the affidavit. Affidavit will file it within 3 weeks.
At least you write something in your
Yes, yes.
affidavit. List the matter again after 3 weeks on a date to be fixed by the registry. The respondent shall file their show-cause reply in the meantime. This was 31, 33. What happened? 32. Of course. Yes, what is this?
But in this, my lord, the document verification for the recruitment process, my lord, is what's going on, my lord. In the meantime, my lord, there was a notification, my lord, person to which this document verification was done. That was put under challenge before this honorable court. And this honorable court, though has not stayed the notification, my lord, but has kept the verification in abeyance, my lord.
By which order?
My lord, the lordship will find the in third paragraph my lord, of the instruction.
What is the order not complied with in this case?
My lord, you will find at page 109, my lord. Sorry, my lord, 106, the operative part. And it's a order of 8 August 2023, my lord. It's almost 2 years. And this issue of DLA has come recently. So there was no issue earlier, whenever the advertisement was done, published.
What is the direction otherwise? What does it say?
Direction is to
Direction
appoint
is to complete the recruitment process pursuant to that advertisement. If so required, my lord, we were also directed to create post, my lord.
The recruitment for the post of
assistant teacher, my
Assistant
lord.
teacher.
any particular subject?
No, my lord. For upper primary and lower primary.
And lower primary.
Then what is this then? This instruction
Well,
which you give?
We proceeded with the recruitment process and the provisional select list was also published, my lord. Now to find out, my lord, with regard to DLED, who are the persons who have completed a DLED, 18-month course, after the Supreme Court judgment, my lord, to find out whether they have completed the DLED within their service, that is prior to 10/8/2017, document verification process was initiated. And in the document verification process, my lord, there were only 4 candidates from the provisional select list who had submitted the documents and the other have never submitted it. My lord, the document verification was done pursuant to the notification of 17/6/2025 issued by the government. That notification, in the meanwhile, has been put to challenge in a repetition.
And they have already verified the documents. The verification has already been completed. So let them publish the select list, my lord. Already they have published 3 provisional select lists. This is nothing but to buy the time, my lord. For last 2 years, they are not complying with the orders, my lord. And this is not a case that it was started in the year 2023. It was started in the year 2021 itself, my lord. Advertisement is of 2020, my lord. It's 5 years back.
Your lordship kindly turns to the next second phase of my instruction.
Mr. Kaushik, why don't you file an affidavit then?
I'll file, my lord.
You file your reply.
File.
Let it be on the record. Mr. B. Kaushik, learned counsel appearing for respondent number,
Sole, all respondents.
appearing for there are two respondents, I think.
Yes, two respondents.
The respondent submits that he has received instructions and that he may be given some time to file show cause reply. Here for above. Is the matter again after 2 weeks.
3 weeks, my lord. Look,
You have to file
perhaps this, the outcome of that repetition will have a bearing.
again 3 weeks on a date to be fixed by the registry.
My lord, that may be fixed by your lordship, my lord.
Registry shall fix the date. Okay. Meanwhile, the respondents shall file their show cause reply, assigning reasons as to why orders of this court has not been complied with till date. Yes.
Once over.
All right.
May it pleases your lordship, here your lordship, we needed to file our detailed affidavit, which we filed today itself, your lordship. Copy has your lordship furnished to the petitioner.
Reply.
Your lordship, let us also bring to the records, your lordship.
Ms. P. Das, Learned Standing Counsel, Secondary Education Department, submits that she has filed the counter affidavit today with a copy to the other side. Stop to this submission. Learned Counsel for the petitioner, Mr. P.B. Majumdar, submits that he may be given some time to file rejoinder affidavit. Stop. In view of above, matter stands adjourned for 2 weeks. Registry to verify and connect the affidavit filed by the Secondary Education Department to the record. And the petitioner may file a rejoinder affidavit on or before the next date.
What is the date we can do it?
List the case again after 2 weeks on a date to be fixed by them.
Oh, agora, public question. What years?
Let it was. You must try to see the order dated last 18/7.
Here also lordship, we have, the department has preferred an appeal and that is lordship.
That with condemnation, my lord.
And that there is also delay there lordship.
Yes. Last order you were trying to see. 18/7.
What has happened to the appeal?
Nothing, condemnation, not yet, simply notice issue, my lord.
Only notices issued, lordship.
Nothing, even with number also not been. And that was filed only after getting the notice from this month. The lordship and say High Court so dated 4/12/23. And we filed the representation certificate copy 18/12/23. Then, my lord, contempt file on 29/7/24, notice 5/8/24. Appeal file my lord, 12/2/25. After getting notice of the contempt petition. But nothing, only they have to place the instruction, my lord, that is that.
Only this, notice in the appeal, issued in the appeal lordship.
Yes, that is that.
It will be an case of next case. So definitely give us some time, lordship.
Mr. Chaudhary will adjourn it for some time.
My lord, one big question, my lord, these persons are serving for 20 to 25 years, man. So one day they have to place my last order is what kind of say, they have to just place them before the state level committee. That is the action, my lord. What prevents them from doing this one?
Since they have decided to file an appeal, so
No, that's true, my lord, but with condemnation only after having this notice of that, yeah, my lord. That's true, but nothing has been done to that appeal, my lord. If you worship this time, my lord, short time only, they have to place them before the committee, but that's much, my lord. Let them decide whatever it may be, when it may go against me also, I have nothing to say, my lord. Then we will take the liberty to propose.
Mr. HRA Chaudhary, learned senior counsel assisted by Mr. S. Islam appears for the
Ahmad.
S. Ahmed appears for the petitioners. While Mr. SMT Chisti
On behalf of Mr. B. Kosik Lordships, on behalf of Mr. B. Kosik, I am submitting the tip.
appears
For
on behalf of Mr. B. Kaushik,
for
who, who represents respondents number two. Respondent number 2. Mr. SMT Chisti, learned counsel submits that since the appeal against the order of the learned single judge, along with the condemnation of application, condemnation of delay application is pending. He prays that the matter will be adjourned. For at least 3 weeks. Stop. On the other hand, Mr. R.H. Chaudhary, learned senior counsel, expresses urgency in the matter. And prays that the matter be taken up for consideration. Stop.
The appeal, I think the appeal kind of, that could be a worship to issue that is what I'm saying.
There's a judgment also. First, you have to decide to contempt them, go ahead. Anyway, however, considering the fact that an appeal has been filed, board deems it proper to adjourn the matter for 3 weeks. Establish the matter again after 3 weeks on a date to be fixed by the registry. Have you filed any show cause reply?
Nothing, my lord. The meantime, my lord, can it be 2 weeks, my lord? 2 weeks, my lord. Your worship.
It will take some time. I'll look after 3 weeks. Look.
Petitioners
Date may fix.
shall file their show cause reply in the meantime.
Yes.
Yes.
Fixed up date, my lord.
Registry will give it after 3 weeks.
Obliged.
I have received the instruction. We are, the SLC has recommended the name of the petitioner for Provincialization Lordships. Now the process is going on for creation by one post. We have to create one post Lordship. And the director has already submitted this proposal to the government Lordship in that regard. So it will take some time. It is on the right direction. Only the director is the party in this contempt case. Now matter is pending for the government. So it will be done, Lordship. It will take some time.
Mr. Please write down, Mr. SMT Chisti, learned counsel appearing for the respondent
Sole respondent.
by producing a letter dated 29/7/2025, written by the Director of Elementary Education. Submits that the DLC concerned has made recommendation in favor of the petitioner. DLC or SLC?
SLSC, Lordship. SLSC has ultimately, they have recommended.
Not DLC, instead of that. SLSC.
Yes.
Has made recommendation in favor of the petitioner. And that the matter is forwarded to the state government for further necessary action. Stop, he therefore submits that he may be given 3 weeks' time to come back with the up-to-date instructions. Will be a follow-up. Is this matter again after 3 weeks on a date to be fixed by the registry? The letter dated 29/7/2025, produced by Mr. S. M. Chief Justice, shall be retained on record and marked as X for identification.
The order is a page 72 rows.
And in this case, I am looking for response number 1, madam. I need some time to take instruction.
Already lordship there, an amount was sanctioned lordship. And this amount lordship for the pensionary benefit, that is from the own fund of the corporation, without any burden on the state government. And all the departments have already cleared, the public enterprise department, elementary department, finance, pension and public given. Only the amount needs to be transferred. And thereafter, tender will be floated for those eligible employees, lordship, the 39 eligible employees. It is now, if there is a delay, lordship, this amount will again rise. It's 15 crore 79 lakhs.
Where is the order?
At page 72, lordship.
72.
Page 70. Okay, only the fund needs to be transferred to the trust. Only that much, Lord. And this is from the own fund of the corporation, not by the state.
You have filed affidavit or Sukia?
No, madam. Madam, I am looking for response number 1, madam. Grievance is again response number 2, madam.
You're for one.
Madam.
Who's one?
What is the
Secretary, School Education.
School education.
Who is the MD? Now, who's to take the steps?
And the services have been completed.
Service is complete, Lord. And lots of the Assam State Textbook Production and Publication Corporation have a standing council, P and Goswami. They have a standing council. On the last occasion also, we have informed before this honorable court that they have a standing council and the service is complete. Despite that, that's it. Yes, doctor.
No, but this is a contempt, you see. Standing council may not appear like that without Vakalatnama. Who is supposed to take necessary steps? The MD
Lots of
or
both.
the secretary? Both.
Both, both.
Somebody has filed a so-called reply? No.
No,
No one has filed.
I am paying for 10 days time, madam. I will take instruction on this.
Okay.
and lots of page 72, lots of, there is already an observation, lots of. Pursuant to the discussions of the employees along with the management and other stakeholders, the Assam State Textbook Production and Publication, pension trust, all clearance from the necessary departments have also been obtained. Actual liabilities have been identified on the basis of the reports, and the administrative department has also granted NOC. So this is our own fund, only lots of needs to be transferred to the trust.
You are Mr. S.K. Das, is it not? Mr. S.K. Das, learned counsel appears for the petitioners. While Ms. S. Sutiel, learned counsel appears for respondent number 1. And prays for 10 days time to receive instructions. No one appears for respondent number 2. Despite the service of notice.
Despite some, also office note dated 11/4/2025.
Stop. Lawazima Court's order dated 11/4/2025 indicates that notice sent to respondent numbers 1 and 2 have been delivered. As per the postal tract consignment. Stop. Notice is therefore accepted to be complete on respondent number 2 as well. As paid for by Ms. S. Sutia, learned counsel for respondent number 1. Matter stands adjourned for 10 days to be listed again on a date to be fixed by the registry. The respondents to file their shopper's reply by the next day.
Public. Also, may kindly give a fixed date also.
They'll give, after 10 days, they'll give a date. Right.
Item 40 also lawsuit, I need some accommodation. I have not received the up-to-date instruction. The hearing was held on 9/6. Therefore, what happened lawsuit, that instruction,
Hearing money, where?
that in this case,
Before whom?
before the director of secondary education lawsuit.
Also, in this case, there is a clear mandamus lawsuit, may kindly see page 21. The impugn order has been set aside, and lawsuit, there is a order to reinstate me as in charge principal. And this order has not been complied. And this order was passed long backwards.
Mr. S.K. Das, learned counsel appears for the petitioner. While Mr. S.M.T. Chisti, learned counsel appears for the
Sole respondent.
sole respondent. And praise, how much time?
1 week time.
A week's time.
Get the instruction.
To obtain instructions in the matter. Therefore, publish the matter again after 1 week on a date to be fixed by the registry.
Okay.
As for all out of 28/7/2000, the new ID card no answer notice is received. Lordship, I will sign this report.
How many respondents are there?
Five,
So let there be some tracking of the,
no lots of notice is issued, but no ID card or answer notice.
that is why I'm saying let the office track the postal consignment.
Lots of,
Your Miss Ashrama,
as you say,
S.
Second.
Miss S.D. Saikia, learned counsel appears for the petitioner. And submits that the ID card is awaited from the respondents. So office note dated 28/7/2025 indicates that ID card has not been received back from the respondent numbers 1 to 5. Stop. Office to track the notice. Office to track the postal consignment. And put up a note by the next date. List again after 2 weeks on a date being fixed by the registry. Service on respondent number 5.
It's completed, your lordship.
And
Perusal to the last order, your lordship. On perusal of last order, it has been inspected. Earlier, the matter has came up in Lawazima, your lordship.
so where is your affidavit? Department.
Your lordship, affidavit instruction, up-to-date instruction is not received, your lordship. Kindly 3 weeks time may be granted to us, your lordship, to file our affidavit.
Mr. M.H. Laskar, learned counsel appears for the petitioner. While Ms. P. Das, learned standing counsel, secondary education appears for the respondent numbers 1 to 4. Of Ms. P. Das, learned standing counsel prays for how much time?
3 weeks
3
time.
weeks time to receive instructions and to file counter affidavit.
Earlier for time given, your lordship.
How many times?
One time.
So,
Second time, your lordship. Your lordship, I'll be filing, your lordship.
Date may be different.
praise allowed. Then
Your first.
next para. The Lawazima Court's order dated 18/6/2025 indicates that
Number. Phone number, copy.
AD card has been received back from the respondent number 5 with signature. Accordingly, notice is accepted to be complete on respondent number 5. This is the matter again after 3 weeks on a date to be fixed by the registry.
I'm deeply obliged.
Respondents to file their counter affidavit in the meantime.
All right. This IA has been filed seeking a direction towards the principal who has unrepresented himself in the matter to comply with the interim order. If I may take a lordship to the interim order. This is at page 16. Page 16 minor. The order is dated 19th of January 2024. I may read that. This writ petition has been filed by the petitioner aggrieved by refusal of the respondent number 4, namely the principal, where the petitioner was working as a lecturer in the geography department, refusing to permit the petitioner to attend to her classes and other connected works, and she is required to perform as the teacher of the said school. The petitioner was appointed as a lecturer geography at Rangsinga Senior Secondary School, West Karbi Anglong on 8/8/1997. Now, this is in connection to a particular cabinet memorandum which I challenged, a clause of which I challenged in the writ petition. That is under adjudication. Now, if your lordship would kindly see page 17, that particular clause has been stayed by this court. Page 17, last paragraph. Notice was issued by this order. It was stayed and the petitioner was permitted to resume her duties. Now, from January 2024 onwards, I tried my best to either serve dusty, which the principal refused, and I took steps multiple times. Finally, the service got affected on 24th of April 2025. That is the Lawazima Court's order. Your lordship will find it at page 19. 19.
Page 19.
19. The date is very important. This is 24th of April 2025. The Lawazima Court says that the service has been deemed to be served. The notice has been deemed to be served on the principal. That means before 24th of April, he has received a copy of the notice. And I myself have also approached him and provided a copy of the order earlier also, although I have not filed any proof to show it. But this Lawazima Court's order is there. He is in knowledge of the High Court's order. Now, thereafter, my lord, at page 22, my lord recalls that particular office memorandum which I have placed under challenge. In regards to that, the inspector passes an order. He passes a direction to all the principals of the schools saying that so-and-so teacher should not be allowed to work. And if it's found, then the principals or any staff will be held liable. Now, this negates me, my lord. I am protected by this court. The interim order stands as on date. Based on this particular order, on May 2025, on 26th of April 2025, that is at page 24, he releases me from service, the principal. And all throughout, he has avoided this court. He has not represented himself.
But I am at a dilemma, my lord. No pay, I'm unable to work despite being protected by this court, my lord. Now, what I'm praying today is, my lord, if a direction is given to the principal to appear personally before this court and answer, routed through the director, my lord, because he has unrepresented himself, routed through the director, then you'll be able to say why he is not compliant. My lord, I have chosen not to drag him to this court through contempt proceedings, and it is always, your lordship always has the power to initiate so the contempt also. Some protection, my lord. Since January 2024 onwards, and because of the procedure of this court, my lord, I was unable to come earlier. Once it has been served, then again, in knowledge, he passes this order, saying this is in compliance to the inspector's suggestion. And if this direction is passed today, your lordship, and if he is given the liberty to allow me to join, perhaps that he might not feel appear personally for this photo. That liberty also can be given.
Where is that interim order?
At page 16, man.
Yes, Ms. Das, what do you say?
Your lordship, we are not representing principal, your lordship. We are only for BSc, your lordship, secondary education.
So notice will have to go then. At this stage.
Well, through the director also, some direction can be given to him. If the director simply writes to him why he has not complied with this order, and he might be given the liberty to allow me to join.
He has made the party over here, your lordship, and order may be passed, your lordship, given his name, your lordship. Because he himself is there, your lordship, made as a party, your lordship, as respondent 4. Respondent 4.
I agree, my lord. But since he has unrepresented himself, my lord,
Your
if I go
what
and serve a
chance may be
certified
given,
copy,
your lordship, if he does not, your lordship, appear again, your lordship, then your lordship adverse may, your lordship, order may passed against him, your lordship.
that is how he has avoided this court. Avoided this court, my lord. Even if notice is issued now, my lord, I will serve a certified copy of this order before him, but he might again refuse to appear.
Then you file an affidavit saying that you served and you had gone to serve and he refused, then we'll see.
Your lordship, through local, your lordship, police station, your lordship, OC, it may.
The inspector is there, inspector of schools is there. I can file another representation before him also. I'm not making the inspector liable for this matter.
OC through legal steps, then if he refused, annex to it, I find it. OC through legal steps, you will be filing more legal steps. Two local officers.
What is this clause 7, which has been stated?
My lord would find it at page, in the read petition, my lord, at page 136, the OM starts. At page 137, second last para is the.
What does it speak about?
It
Clause
says,
7?
the DEO must ensure that non-provincialized teaching staff, non-teaching staff should not be allowed to serve in a provincialized school. In future, any such references are found, personal responsibility shall be fixed upon all the erring officers. That is what is reflected in the inspector's letter also, which I have connected in the act.
Heard Mr.
P. Bharadwaj.
P. Bhardwaj, learned counsel for the applicant, who submits that by filing this application, the applicant seeks for a direction for compliance of seeks a direction to the respondent number 4 for compliance of the court's order dated 19/1/2024, filed in WPC number 147 of 2024. The learned counsel submits that the respondent number 4 has refused to accept the order of this court dated 19/1/2024. For that reason, the petitioner, the applicant has filed the said application seeking compliance of the interim order. Next para, in view of above, issue notice to the respondents. Ms. P. Das, learned standing counsel, secondary education. Department accepts notice on behalf of respondent numbers 1, 2, and 3. Petitioner, the applicant shall serve notice to respondent number 4 by registered post with AD due, as well as by way of Dasti through the registry of this court.
And also one through the officer in charge of the local police station. It can be done.
Officer in charge, why do you want that? Any problem?
Then she can, and then he cannot refuse it. And it will take.
The
it will
usual
be in
process can be
record.
routed through the officer in charge of the local police station. I have done this earlier on. Even my learning.
Usual process.
Yes.
Usual process through the officer in charge of
Officer
the
in
local
charge
local
of
police station.
Indian police.
What did I say? Now, as well as the remaining, but as well as by usual process through the officer in charge of the police station concerned. Then who will report back?
The OC will report back. Or the process server of the municipal, of the local, who has local police station.
They report back normally.
In this case, in fact, I have taken steps, usual process to the process server of the wood chief of that particular. That is there in the order.
But then you said OC of the police station concerned.
That can also be done. But I'll do the
OC is better, I
report
think.
back. The OC.
Officer in charge of all.
List the matter again, when?
A date after 3 weeks, because of the non-compliance, and that's why I'm seeking a date.
Registry will fix a date, on a date to be fixed by the registry. After 3 weeks.
I'm deeply obliged.
Suddenly, my lord, by the interim order, my lord, let's just say, he has been, likely to
One junior teacher has been given the source of investor. Last year, the lordship was pleased to reach on 18th. Petitioner is senior, my lord. He is holding the source of headmaster of the school since 2013, madam. Kindly have a look to answer 6, my lord, page 22.
Here, my service report is not completed, my lord, as private respondent. Everything check from my lord.
Look on last year, my lord, paid for lordship for Indian protection, madam. And lordship was pleased to reach on 18th, my lord.
That's correct, but let's see, let the service be complete.
Yeah.
Office note, please write down, office note dated 28/7/2025 indicates that service is not complete upon respondent number 5. Stop, it is seen that notice was sent to respondent number 5 by registered post on 8/7/2025. Stop, therefore, registry shall track the postal consignment and put up a report by the next date. Stop, list the matter again after 2 weeks on a date to be fixed by the registrar.
The date will be fixed. The date will be fixed.
Registry will fix the date.
May I please, my lord? My lord, in item 45, by an order of 30th June, my lords were pleased to issue notice and also grant an intent protection in my favor, my lord. My lord would have 30th June order. This pertains to some documents verification in an ongoing recruitment, my lord, and I had challenged the basis on which these documents were being sought. My lord would simply have the order of 30th June, my lord. The relevant part being para 11, my lord, on the second last page. May I read, my lord?
Yes, read.
My lord, may kindly have para 11. Upon considering the submissions made by the learned counsel for both sides and also considering the entire facts and circumstances of this case, it is seen that as per the order of the Honorable Supreme Court passed in so-and-so, the qualification obtained by NIOS shall be treated as valid for all the intents and purposes provided the candidates was in service as on so-and-so and having 18 months DLED from NIOS. But from the notification, which is the impugn notification, my lord, which is under challenge, it is seen that as many as 6 number of documents were asked from the candidates for verification along with 18 months DLED certificates and mark sheets through NIOS of the applicants. Thus, from the notification itself, it is seen that though some list of testimonies documents were sought from the candidates, but it cannot be held that there is any apprehension of cancellation of the candidature of the present petitioners. Further, the completion of verification also may take some more time as submitted by Learned Standing Council Elementary Education. Thus, at this stage, this court is of the opinion that there is no necessity of suspending the impugn notification dated so-and-so, issued by so-and-so. However, very, very important, my lord, result of the verification may be kept in abeyance till the returnable date. List the matter on so-and-so. In the meantime, respondents may file their affidavit in opposition. But to the best of my knowledge, the affidavit in opposition has not been filed till today, my lord. So, my lord, the state will have to file their affidavit in opposition, my lord. And if my lord would want, I can explain the matter also in 2 minutes if my lord would want to have a gist of the matter.
Yes.
Yes, Lordship, today it's come for orders. I think services yet to be completed on the phone number.
Which respondent?
NCP, Lordship.
Number 5. Who's respondent number 5?
Respondent number 5 is NIOS, my lord, National Institute of Open Schooling. My lord, if possible, my lord may delete, but they are not relevant parties here, my lord. We had made them initially because they were parties before the Honorable Supreme Court. But if my lord would feel that this will come as a hurdle in the present matter, we can delete them at our risk and for the petitioners. The respondent number 1 and 2 are the necessary parties which were represented on the day of passing the interim order.
Orders will file our affidavit.
How much time?
Not to 2 weeks time.
You're good.
I'm sorry, Mandeep Kalra, my lord. My lord, can I make one request if my lord would permit?
Yes.
My lord, there is one IA for Impleadment that has been filed by similarly placed petitioners, my lord, which is IA 2359 of 2025. my lord, the case of the implead petitioners and the present petitioners is identical, my lord. So, my lord, that IA may be allowed. There are at least 32 more petitioners in addition to the 139 which are there before in the writ petition, my lord. They are identically placed, my lord. And they were also.
No, I is not listed today,
Yes,
isn't it?
not listed today.
It's not before this court.
I'm so sorry, my lord. By the next date, we'll have it before the honorable court. Lord, can I just make one last request, my lord? Lord, the recruitment has been going on, my lord. So therefore, my lord, if I can pray for a date next week, my lord, because this result, the interim order which has been passed, my lord, the results have not to be declared. Till the time the impugn notification is decided, my lord, in terms of the Honorable Supreme Court's order and in terms of the history of this matter, my lord, because this matter has been going on for the past 8 years. 8 years, there has been some history which is involved. Till such time, the recruitment cannot be completed. And all of us are jobless people, my lord. From the last 8 years, we are teachers, my lord. This is a teacher's recruitment. So therefore, my lord, instead of 2 weeks, because they were given 4 weeks on the last day, my lord, can 1 week be given because they were present on that day. It is not as an ex parte order, my lord. On that day, they were present. In their presence, this order was passed. And they themselves asked for 2 weeks. I'm sorry.
And 2 weeks, within 2 weeks, it not going to be completed date. Possible.
How much time should you require?
10 days.
10 days.
10 days.
All right. Heard Mr. M. Kalra, learned counsel for the petitioners through video conferencing. And also heard Mr. SMT Chisti, learned standing counsel, elementary education. Appearing for respondent number 1 and 2. Stop. The learned counsel for the petitioner submits that respondent number 5 is basically a pro forma respondent.
Indeed.
And may be deleted from the arrayed respondents. Stop. He also submits that there's urgency in the matter, and for which a short date, and for that reason, a short date will be fixed for considering the extent petition. Next para. Considering the submission made, respondent number 5 is hereby deleted as from amongst the arrayed respondents. Stop. Registries to do the needful. Stop. Mr. SMP Chisti, learned counsel for the learned standing counsel for the elementary education department, submits that he needs at least 10 days time to receive instructions and file the affidavit in the position. Stop in view of our registry to list this matter again after 10 days on the date to be fixed by it. But in the meantime, the respondents shall file their counter affidavit. The interim order passed earlier shall continue till the next date of listing.
I'm so deeply grateful, my lord, deeply grateful.
All right.
May I please as a lordship?
Yes.
Lord, this is a matter, my lord, pertaining to a different bench, my lord. But the issue is that, my lord, the regular benches, many of the judges cannot take up. The client is known to them, my lord. That's why, my lord, this matter has been perhaps referred to my lordships. My lord. Matter relates to, my lord, demolition of a very permanent structure, wherein, my lord, the petitioner is now just taking shelter, my lord. Now the JMDA and JMC, my lord, they both are behind me, my lord, asking for my permission, and lots of harassment is going on.
Okay, which bench is this?
My lord, the bench, I think it's bench 5, my lord.
Bench 5.
5, my lord.
Then why is it listed here?
Yes, my lord, because the regular benches, my lord, which is already taken up, honorable 3 judges, my lord, has already not filed, because, my lord, the client known, my lord, not paid. He is also a lawyer.
Then you submit an application
My lord.
for constitution of a bench for this case. Because
The regular bench cannot take up, my
I
lord.
understand, that is why.
My lord.
In this matter, my lord, I'm for respondent number 4, my lord.
No notice, no copy has been sent to me, my lord.
No, my lord, we have
on the-
taken the stamps by registered post, my lord, and that service is complete. If my senior friend wants a copy, my lord, then we can furnish, my lord, there is no problem. But no copy is, that is, my lord, not correct, my lord.
As per original court order, my lord, some other person has received that notice, my lord. Is it not related to me and is not person, my lord.
We can serve, my lord, there is no problem.
Yes.
But my lord,
No objection on that.
but my lord, the difficulty is that we are apprehending a demolition, my lord, in the IA. Basically, my lord, we have bring into my lordship's kind notice, my lord.
No, since you have told me that this is a bench five matter,
My lord, my lord.
so perhaps it will not be proper for me to pass any order at this stage. We'll list it before the appropriate bench, and in the meantime, if you want to take steps, you can take steps in the sense that you can request,
My lord,
you can approach the registry with an application saying that since the matter has been deferred by the considered bench, it may be late before an appropriate bench for consideration.
Lord, what has happened, my lord, earlier 2-3 times, the matter had already been taken up by the appropriate bench 5. Now, my lord, when the matter came up, then the, my lord, honorable judges.
They are recused.
Recused the matter because of.
I've seen it. I've seen it. There are three orders here
Three orders.
of recusal. So that is why I'm saying, let it be taken up administratively. Because if it's a bench 5 matter and I pass orders, it will not be proper. I'm assigned only bench 2. Please write, parties are represented by the respective councils and they submit that the instant case is a bench 5 matter. Stop. They also submit that since they also submit that although the matter was listed before bench 5, but the presiding judge, three presiding judge in bench 5 has accused from taking up the matter. To stop, if that be so, applicants, the petitioners, the applicants are at liberty to approach the registry with appropriate application for doing the needful. Stop, list the matter before the appropriate bench.
One copy. Copy of this.
Give a copy.
That order, my lord, said,
Not pass my.
My lord, I am giving assurance before my lordship, I will furnish a copy. It will also help our cause, like expediting.
Yes, give a copy. I'm not including that in the order.
Fine.
Give him a copy.
Obliged. My lord, what has happened, my lord, in the main writ petition, my lord, we have challenged the transfer order. And this honorable court was pleased to issue notice, my lord, and the issue of the transfer order is already under examination. Now, my lord, suddenly, my lord, we have received a so-called notice, the petitioner, from the inspector of school that why you have not come and joined me. My lord, may be pleased to find that.
Is there a stay order?
No, my lord, the stay is not there, my lord, but the.
Obviously, that will come so close.
So, my lord, that's why we are praying for in the IA, my lord, for an interim protection.
After receiving so much.
My lord, we have to take shelter before my lord, there is no other way out, my lord. Even, my lord, we have responded to the so-called also, my lord. No? We are in the IA, page 18 is the so-called. Lord, what has happened, a series of such transfer order had been issued, my lord, and in those cases, there is a stay order had already been passed, but my lord, as the petitioner has approached belatedly, my lord, that's why there was no any interim protection provided, though notice had been issued, my lord.
There was a delay. There was a delay.
Delay
There was a
in-
delay
in-
in filing the thing, man.
Filing-
the case.
You didn't find the case?
Yes.
The writ petition?
Yes.
What do you say about this IA?
I don't have the copy of the IM. Just got the petition, read petition copy.
We have, my lord, without serving copy nowadays, filing is difficult, but we have served, but perhaps it is not with my learned friend. My lord, I can serve an extra copy also.
Yes, give him an extra copy.
Fine.
But my lord, only thing, my lord, we are praying with a, my lord, case law cited by this honorable court. My lord, my lordship is well aware, my lord, in the Akata Sali versus the state of Assam and others, my lord, reported in 2014 4 GLP 55, wherein, my lord, this honorable court has held that when the matter is in session of before my lordship, my lord, the department cannot start a parallel proceeding. So, my lord, under that principle, my lord, this so cause, my lord, cannot stand.
Writ petition was filed against order of transfer. Notice was issued. Meantime, he has not joined, so they gave him a show cause. And now he's come with an IA today saying that some protection.
I may be given the copy of the IA, my lord, and my matter may fix on some other date, my lord, and therefore, my lord.
Lord, I can start, my lord, till then status quo as on.
My lord,
We kindly turn over to page 15 of the read petition. Page 15.
Writ petition.
Yes, paragraph 9. He has stated that he has already joined a new place of posting.
No, my lord, I have joined, and my lord, my learned friend has not referred the later paragraph. There is a, my lord, in paragraph 10, my lord, that has not been read over by my respected learned senior friend, my lord. Paragraph 10, my lord, at page 60.
Just a
Mile.
paragraph.
My lord, paragraph 10 at page 16.
What is the representation?
Lord, once I joined, my lord, then I have been allowed to again come back to my original school. Although there is no order passed by the inspector of school, my lord, and thereafter, I stating in detail in, my lord, this representation, apprised the, my lord, deputy commissioner of the district, my lord, who has issued that representation is also here, my lord, before my lordship, my lord, is a annexure relevant.
No, where's the statement that you've been permitted to go back?
Lord, where he's submitted, he returned to his earlier school of working, that is Ajmal Khan Girls Pre-Senior Madrasa, where he is continuing to work till date. However, at the same time, the petitioner on 7/10/2024 submitted a representation before the District Commissioner Hujai, highlighting his grievances against the impugned transfer order, stating his difficulties and health issues and praying for allowing him to stay in his earlier school, and if not, then to at least allow him to join in a nearby school. Especially as because under some clause 12 or clause 4 of the office memorandum dated, it has been stated that the teachers with the health issues should not be posted in difficult areas, and that such teachers would be preferred for posting in areas with a better road connectivity. However, the representation was not received from so and so. Thereafter, again, preferred another representation, but this time also of the petitioner was not received at the office of the. He had even submitted a copy of the before the concerned district elementary education officer Huzar, requesting for considering his prayer, but even the office of the refused to acknowledge the representation of the petitioner. This is the, my lord, what, my lord, I have submitted fairly before my lord. This is the situation, my lord. He is now still continuing in his original school, and that is known to the respondent. Now, when I approach before my lordships, my lord, then only belated stage when the notices has been issued by the respondents, my lord, this so cause have been issued. Now, my lord, as the, my lord, my transfer order can sustain or not, as my lordship is examining, my lord, at this moment, they have issued, initiated a parallel proceeding regarding my conduct, my lord. And this has been well settled, my lord. In many cases, the judgment has been referred that when the matter is in session before this honorable court, my lord, the parallel proceeding is not justified, my lord.
Then you go back to the school where you are posted.
My lord.
You go back to the school
To
where
the
you are
school
posted.
wherein, my lord, I have been transferred. My lord. And my lord, my petition will become, my lord.
Go and join Ashim Nagar ME school. Project.
Lord, I had already there, my lord. I went there.
You went there, you came back again, so this is some kind of internal arrangement. So authority says that what is this? Show cause.
My lord.
What is wrong with that?
No, my lord, as I have challenged the very foundation of the my transfer, my lord, from my lord. My lord. And my lord has not dismissed my petition, is still under examination. Now they are trying to overriding the judicial exercise, my lord.
Yes, Mr. Pugan.
Whatever your chief has said is correct, ma'am. On the basis of we being joining his new place of posting, there was no interim order. And lordship will decide later on whether that transfer order was right or wrong. But the lordship, after joining in, can come back to his earlier school
Normally
without
that
there
is,
being any official order, lordship.
no, normally that's not done, and moreover, how will he get salary also?
Yes, lordship.
My lord.
Your salary will be again.
Substantive post is in
The post.
another school.
Salary, my lord, I am getting from my original school. My lord.
Original school.
Now they, because of the exceeding and the consent of the respondents, my lord, I am getting.
Where is the show cause notice?
Is that page, my lord, page 18 of my IM, my lord, Annex 2.
You have also given reply.
My lord, I have submitted the reply. My lord.
Then
But my lord, after this reply, I am apprehending, my lord, that something.
Lord, copy may be served upon us, the IM.
I have served a copy, my lord can fix it on next Friday, my lord, coming Friday. My lordship, my friend is handicapped, my lord.
Copy here, so they could find out. And I'm going to piece of this.
next Friday is what date?
Any convenient day, my lordship.
It will not be convenient. Mr. Pugan, can you get instructions?
I'll get my instruction also, my lord, but first let him serve me the IM method. Because
Lord, in the main read also no affidavit till date, my lord.
25 matter, my lord. So 25 matter, my lord.
My learned friend is submitting, you know, this is a 25 matter, so affidavit is not required.
Well, I'm not saying not required. We'll filing it. We're awaiting instruction.
Even if it's ready, since it's too new, they'll not file. They'll wait for some time.
Awaiting instructions. Awaiting.
We will get instructions. I think we'll give you 10 days time.
10 days, man. 10 days.
Ask Mr. A.R. Bhuiyan, learned counsel for the applicant to submit that by filing this application, the applicant seeks a direction to the respondent authorities concerned not to proceed, not to undertake a parallel proceeding provide show cause notice dated 18/6/2025, pending final consideration, their main rate petition. Mr. A. Bukam, learned standing counsel. Elementary, is it?
Yes, sir. Elementary appearing for 1, 2, and 4.
Application appearing for respondent numbers
1, 2, and 4.
1, 2, and 4. Accepts notice. Before that, you write issue notice, huh? Then Mr. So-and-so accepts notice on behalf of respondent numbers 1, 2, and 4. Mr. B. Chaudhary, learned standing counsel. SSA accepts notice on behalf of respondent numbers 3 and 5. Mr. B. Diori, learned government advocate, accepts notice on behalf of respondent number 6. This matter again. After 2 weeks.
2 weeks.
On a date to be fixed by the registry. The learned counsels for the respondent shall obtain instructions by them.
PPF letter.
The next day for an status quo.
My lord, that will not be given now. He has not done anything adverse. We will not do.
Then no forcing action.
That may not be given.
If something happens, we'll see.
Why?
As of now,
Oblige, we'll take it up.
PPF letter.
Instruction.
The affidavit has not yet been filed. Affidavit is required, matter of provincialization.
yes, when will you file affidavit?
4 weeks time may be granted. Okay.
Mr. A. Bhuiyan, learned counsel appears for the petitioners. And Ms. P. Das, learned standing counsel. Secondary education appears for the department. And seeks for 4 weeks time to obtain instructions. To receive instructions and to file counter affidavit. Prayers allowed. List again after 4 weeks on a date to be fixed by the registry.
Oblige, highly.
This case specifically filed on the ground that petitioner were appointed long back. And they are governed by the old pension scheme, but they have been, government has taken an undertaking that they will be governed by the new pension scheme. And already, Lordship, this court has already passed an order, similar order, that petitioner be governed by the old pension scheme. The Punima Ojai's case by the long, lot of cases were disposed of by this honorable court. Secondly, in WBC number 3779 of 2023, the petition has been disposed of directly in the old pension scheme.
After some time, my seniors on this election.
Who is it?
Let me Mr. Eli for this.
So Lordship, fix a date, Lordship, otherwise Lordship, I have to wait.
He's on his way. He's on his way.
I think this is only 2 cases are left, so. You say it's covered by the recent judgment.
Because regarding stipend teacher already, Punima Ojai's case, that.
What is the judgment? So Mr. S. K. Goswami, please write. Mr. S. K. Goswami, learned counsel for the petitioner, submits that the case of the present petitioner is squarely covered by a recent judgment of the coordinate bench of this court, passed on 17/2/2025 in WPC number 3779 of 2023. Open bracket, Sri Rupak Chandra Kalita versus State of Assam and others. Mr. Nayak, you examine this judgment and will fix a date.
Lordship, in the meantime, Lordship, in WPC 6020/2017, these are a batch of cases, Lordship, that has been disposed of by a single bench of this honorable court. This is exactly similar, and on the basis of that judgment, Lordship, another judgment was passed in 4636/2024. In which case, in that case, Lordship, prayer was same. Prayer was same. I mean, petitioners are same batch, Lordship. In this case, prayer was also same for benefit under the old pension scheme, which is the present prayer in the present jurisdiction. So that case has also been disposed of by this honorable.
What is the outcome?
It was rejected.
Rejected. This was allowed.
This is allowed, and Purnima Hojai's case, stipulated which has been allowed by this one. In case of stipulated teaching, we are also stipulated teaching.
So it's covered both ways. One says it's covered allowing, one says it's rejected.
But
I
in
do not
this,
know the facts of the case.
in this case, Lordship,
Then Lordship will fix this matter.
I'll record that also.
Lordship.
Next para, on the other hand, Mr. P. Nayak, learned counsel appearing for the BTC, submits that. Oh, give me that judgment. A coordinate bench of this court. In a case of similar nature, had rejected the claim of the petitioners.
As per my knowledge, also the RDS series has been disposed of regarding areas.
No, that series was in respect of various salary, but the subsequent judgment, Lordship, that is 4636/2024. As the petitioners belongs to the same batch.
Okay. In this connection, after full stop, the learned counsel refers to the judgment and order dated 14/7/2025, passed in WPC number 6020/2017. Open brackets, Ganesh Narzari and 116 others versus what state of Assam and others. And order dated 25/7/2025. Passed in WPC number 4636 of 2024. Open bracket, Mangal, Rava and 18 others versus state of Assam and others.
I think this is it regarding areas.
By which the earlier judgment rendered in Ganesh Narzari and 116 others, Supra, was relied upon. To stop. Next para, in view of above, the learned counsels appearing for the rival parties shall examine the authorities relied upon by them and make their respective submissions by the next date. List this matter again after 2 weeks on a date to be fixed by the ministry.
Compliance.
Yes.
In this matter, pleading is complete, my lord. The matter is listing for admission since August 2024, my lord. And Lordship kindly have a look on the petition is for interim, my lord, since 12/1/2024 team league, my lord. And I'm been selected for the assistant professor in the, and my selection was challenged before this court.
Pleadings is not complete.
My lord, if it is exchanged, my lord,
No, there was a direction also.
to the petitioner, my lord, since he has to, till date, no affidavit filed petitioner, my lord. As per the last order, my lord, can you have a
2
look
weeks'
on-
time is granted to the petitioner to obtain instructions then to file in response to the additional affidavit. That was the order.
Till date, no affidavit filed by petitioner, my lord.
Lordship senior is coming.
Huh?
Senior is coming.
Senior is coming. Who's your senior?
PJ Pukon.
Sorry?
PJ Pukon.
PJ Pugo. Are you going to file affidavit or not?
Yes, I will going to file.
I'm raising his eligibility and maintainability of the petition this question.
You are appearing for
Respondent 7, my lord, the private respondent.
private respondent number 7.
Yes, my lord.
What is the issue regarding?
My lord, for the post of assistant professor, my lord, for chemistry subject, my lord, and I've been selected, my lord, challenging my appointment, my lord, obtaining my additional and obtaining an stay, my lord. Then thereafter, my lord, after staying, my lord, I'm unable to join because of this pending.
Assistant professor.
Assistant professor
Lec-
chemistry.
In chemistry.
Chemistry.
Where? In which college?
My lord, it is a Basugao. Lord, Basugao College in the district of Chirang.
Okay, that has been challenged by the petitioner.
Yes, my lord. So my matter may be hard, my lord. Yes,
Mr. Pukan,
Milord,
you were supposed to file some affidavit
Milord,
in terms of the last court's order.
since, Milord, it's, the additional affidavit filed by my learned friend. It's regarding that, aspect of law, Milord, PCC regulation. And the office memorandum issued by the government. So, Milord, no affidavit would be required.
Then on my lordship may taken up, my lord.
Yes, some will be taken up today itself.
Then, you know, can it be next Tuesday, my lord, then this time, it will take some
Yes,
time.
it'll
my
take some time, otherwise
Next Tuesday, my lord.
we don't want to leave unfinished business every time. Later on again, we'll have to start from the beginning.
Yes, my lord. My lord, can even next Tuesday, some urgency from both
See,
sides, my lord.
I don't know, Tuesday, we also have a calendar, fixing cases, I don't know what is the 50 matters. 50 matters.
Then, my lord, 5th of August, kindly.
That's the date. What about 19th?
19th, my lord, before independence, my lord, is possible, my lord. Since 2025.
We don't want to become independent. First you get independent, then you will hear the matter.
Then, instead of 19, Milord, a case has been fixed by your lordship, Milord, on that day.
21. 21.
21.
All right. Mr. PJ Pukan Lanet, counsel for the petitioner submits that the petitioner will not be filing additional affidavit after all. Stop. The learned counsels for the rival parties submit that the pleadings are complete and therefore the matter may be taken up for admission hearing. Stop. As paid for this matter on 21st of August 2020. Right.
Since the 2024 January opening interim order, so my lord, my humble prayer, matter may be endeavored shall be made to discuss the matter.
For admission hearing.
Can it be on fast citing as admission?
No.
Some observation regarding this point.
And endeavors may be made, Milord.
Yes, my
All
lord.
right.
Yes,
An endeavor shall be made to dispose of the matter on that day.
deeply obliged, my lord. Most of it. Deeply obliged.
In this case, my lord, petitioner before this honorable court, the senior most, my lord, professor, my lord, assistant professor.
Senior most?
Yes, my lord, senior most professor, my lord.
Professor.
Yes, my lord. He was appointed as a lecturer. Subsequently, my lord, senior most assistant professor. He was allowed to, my lord, work as a principal of my lord, Sontoli College, my lord. But here, my lord, Annexa 10, my lord, page 46, my lord.
What is this IA?
I is, my lord, during dependency because again another improvement order has been issued, my lord, by the director, because my in-charge order was given to me, my lord. Subsequently, it was given to this junior, to me, one candidate, assistant professor, my lord, that order has been challenged by me. My lord. One junior person has been, my lord, appointed instead of me, my lord. That's why, my lord, kindly peruse your lordship, page
That's
40
why you filed the WPC.
Yes, my lord. The kindly peruse your lordship, page 48, annexure 11.
No, IA is before me only.
Yes, IA is, my lord, I have challenged the, I have challenged that order, extension order. Because the junior person may again allowed, madam, even after filing the petition, seeking copy of the notice.
Okay,
Page 11, madam.
11 of the writ petition.
IA, madam, IA.
11 of the IA.
IA.
Okay.
From 3 months. Earlier was 3 months, subsequently given to the, that charge, madam. Confirm.
Page 11.
Yes, madam, page 11, in continuation of this office letter number so-and-so dated 2/9/24, the terms of the principal in charge, drawing and reversing officer of Sontuli Ansolik College, post office so-and-so.
This is infructuous.
Yes, madam.
3 months is over already.
Yes. Earlier was over, but in respect of Dr. Mubarak Ahmed, assistant professor of the Department Arabic of the college, is hereby extended for a further period of 3 months under FR 49C with effect from 1/12/2024. Subsequently, he is continuing till date, my lord. But initially, I was allowed to, my lord, take that charge, my lord. I have mentioned, my lord, in my representation, can you peruse your lordship, last page of IA, my lord, page 12.
No, your IA becomes infructuous. You need to file another IA, maybe.
No, my lord, already I have challenged the main order. This is in addition to this earlier order, it was an extension given, that's why I have.
Correct. The IA is solely for the purpose of challenging the extension.
Extension.
Extension was 3
Along with
months.
the main order.
3 months already over
Over.
in March.
But still that is continuing. my lord. Now, can you peruse the
Then,
page 12?
then this can be disposed of as infructuous. IA.
I am just I have to bring notice about the extension of the order because already order has been passed by the.
How will you bring that?
Because my lord, already improved order passed page 51. Can you please the lordship, page 51, last page of my rectification. Please.
All right, we'll fix a date.
My
Oh,
lord,
here. Any private respondent here? You are there for the private respondent. Have you filed affidavit?
or your lordship may dispose of my representation also, my lord, in accordance with law.
Which one?
Page 10 and except in petition 46.
Page 10.
Page, my lord, page 46.
46.
Yeah, and except 10. Because I am the senior, it is, in the list also it is evident that he is the senior most. Page 48, Nausad Ali Ahmed at the top, number 1. The second has been handed over that charge.
Who will dispose of?
And this is secretary to the government of higher education department.
Otherwise, 51 also only for 3 months. They are after 3 months.
Now he is continuing in view of this order.
I have to take his continue.
Continue. That's why.
We dispose of it.
To dispose it of. Third, Mr. H. Das, learned counsel for the petitioner. Mr. Your good name?
As we are.
Yes, we are learned standing counsel.
Higher education.
Education Department. Correspondent numbers 1 and 2. And Miss S. Dihinga, learned counsel for respondent. Principal. You're for the principal. Then who's for number 5? Mubarak Ahmed. No one.
Yes. So, one is my lord, principal come drawing and disbursing officer 4. And 5 is Mubarak Ahmed. This is holding the post. That's why he by name. He has been implicated. This also for.
No, 4 and 5 are same.
Same, man. At
You
present.
so you are for 4 and 5. Correspondent numbers 4 and 5. Stop. It is the case of the petitioner that he is the senior most
Best 48.
page 48.
Yes, senior PD.
Where's your name?
That, serial number 1, Nausad Ali Ahmed.
Huh?
Second is my lord,
Where is that? Page
8 of my petition, annexure 11.
Okay, this is the petitioner.
Yes.
And the private respondent?
Private residence, at serial number 2. The joining service 93.
He is the senior most assistant professor working in Sontali Anchalik College. Kamrup District, Assam. And therefore, he should be given the responsibility to be the in charge principal of the state college. Stop, however, ignoring his seniority, the respondent authority concerned has placed the respondent number 5, who is much junior to him, as the in charge principal. Stop, agreed. Petition is before this court. Next para. During the pendency of the writ petition, the respondent authority concerned had issued. No, you write like this, not respondent. The Director of Higher Education had issued an order dated 13/12/2024, by which the
Is another repetition, but that order was extended by this order. And it's at 13 page 51, the repetition.
the order by which the respondent number 5 was kept as the in charge principal was extended for another 3 months with effect from 1/12/2024. Stop. In view of such development, the petitioner had filed IAC number 83 of 2025. Stop. Although the period of 3 months have already expired,
Till that is 14.
the respondent number 5 still continues to be the in charge principal of the college. Stop. Mr. H. Das, Learned Counsel, submits that the limited prayer of the petitioner at this stage is that the representation filed by the petitioner on 17/8/2024, bracket annexure 10.
And my lord, 4/12/24.
Where is that?
In IA. Next, last page. 4/12/24.
But this is before the director.
Oh, yeah.
Secretary will be better.
Yes, my lord, that will be better.
May be considered and disposed of by the Secretary, Higher Education, Government of Assam. By way of a speaking order within a time frame. Stop. Next para, considering the above submission. The writ petition is disposed of with a direction to the Secretary to the Government of Assam, Higher Education Department. Bracket, respondent number 1. To dispose of, to consider and dispose of the representation of the petitioner dated 17/8/2024 by way of speaking order within a period of how much time?
1 month.
1 month from the date of receipt of a certified copy of this order. I've given that secretary nomenclature, and yes, it's secretary government of Assam. It should be secretary to the government of Assam, second, higher education, okay? Like that. Then in the IA, right, in view of the order passed today, in the main writ petition, the IA also stands disposal. Then one more line before that, in the writ petition, right? The order to be passed by the respondent number 1 shall be communicated to the petitioner.
I left it. I left.
That's all.